Chers collègues, je propose que vous preniez votre siège parce qu'on veut redémarrer pour la séance de l'après-midi. Pile, on suit exactement le temps. Et on va commencer cet après-midi. Comme vous le savez, en préparation de cette conférence, on a envoyé un questionnaire à nos membres. On a reçu des réponses et on est très heureux que les gens du Grantham Research Institute on Climate Change and the Environment from the London School of Economics and Political Science. Je pense que en Europe, c'est l'institut principal qui s'occupe avec le suivi de la jurisprudence en matière climatique. On est très heureux qu'ils ont accepté de faire le travail de synthèse. Et donc, ce travail de synthèse vous sera présenté par Harsh Narula et Kate, je viens de... Et normalement, Johanna Setzer serait présente, mais malheureusement, il y a un souci de santé dans sa famille, donc elle ne pouvait pas être ici. Et je cède immédiatement la parole à Harja.
Thank you so much, Luc, and I'll kick us off. And as Luc says, I have to start, I'm afraid, with an apology on behalf of our colleague, Dr. Johanna Setzer, who couldn't be here with us today due to a serious illness in her family, but who sends her regards. And also to start by saying thank you so much to the European Forum of Judges for the Environment for inviting us to participate in this conference and in the preparation of this extremely interesting report. We were delighted to have the opportunity to read so many responses from national rapporteurs. So what we're going to talk about today, I'll introduce very briefly the work of the Grantham Research Institute in this area and explain why, as we understand it, we have been invited to speak to you all on this topic today. I'll then hand over to my colleague Harj, who will be presenting the findings from our report in some detail. The report, I believe, was circulated in advance of the conference. I'll then take over again to talk a little bit about what we anticipate seeing in the future in terms of climate change litigation in Europe and some of the recommendations from the report. And then we're hoping to have at least sort of 20 minutes of the time that we have for a discussion with all of you about what you see as sort of future trends and key issues for judges on this topic. Farah, could I ask you to, yes, okay, I'll start and we can pick up the slides when they're ready. So just a quick note about the Grantham Research Institute. We are an institute at the LSE. We were founded in 2008 by Lord Nicholas Stern, among others, really in the wake of the Stern report, which was an economic review of the consequences of climate change that was very informative for UK policy at the time. And the Institute primarily focuses on economics, but we have a small and growing area that works on governance as well. And our work on climate change litigation really fits within that. Johanna Setzer has been leading this work since 2019, and one of the things that we have been doing is producing an annual snapshot report following the growth and development of the field of climate change litigation over the course of each year and pinpointing new trends as they develop. Next slide, please, Farah. Or perhaps another one along. Perfect. And we're very proud over the years that these reports have become fairly widely used as a resource by many different stakeholders. We get a lot of interest in the reports from journalists, scholars, lawyers, increasingly central bankers, financiers, and many others. And we think that this tells us something beyond the fact that the reports are popular, but it tells us quite how important this area of work really is. There is such broad interest in what courts are and are not doing and saying on this topic of climate change. And so it's, I think, really critical to have this discussion with you as representatives of those courts. And one of the things that I would point to before talking very briefly about the sources for our reports, which we've drawn on in addition to the reports from national courts for this discussion, is that earlier this year, the Intergovernmental Panel on Climate Change, which is the international body of scientists tasked with tracking climate change developments, recognized for the first time the role that climate change litigation has played in the international governance of climate change. And they highlighted in the summary for policymakers, which has to be agreed by every country, that climate change litigation affects the outcomes and the ambition of climate governance. So really critical at this point that courts are playing such a crucial role. Next slide, please. So the final thing I wanted to talk about before I hand over to Haj is the databases, which are the source for this report and for our Global Trends series. There's two databases, the Climate Change Laws of the World database and a database called the Climate Case Chart, maintained by the Sabin Center for Climate Change Law. Between them, they include over 2,000 climate change cases and more than 3,000 climate change laws and policies, all of which, of course, is matter to be interpreted and to be understood. And we used information from these databases alongside the information that was provided to us in the national reports to understand and pick out some of the key trends in Europe that Haj will discuss now.
Thank you very much. Thank you, Kate. So I'm going to be taking you through the report that we've written, which is divided in two parts, which will be the structure of my presentation. Part one of our report looks at trends in European climate litigation. So I'll take us through some of the key figures, case types, and an analysis of the different strategies that are used in European climate litigation. The second part of the report focuses on drawing out some of the common issues that we identified from the survey responses that we received from all of you. We were very fortunate to have a very high response rate to the survey, with 21 forum members sending in reports from across the continent. So we have a really rich resource from which we've been able to draw the conclusions of this report. Before I come on to part one, though, I'm going to start with a discussion of the definition of climate change litigation, which is still a contested concept. Farah, if you can go to the next slide, please. Thank you. So, given that climate litigation has only emerged as a substantial field in recent years, its exact scope is still somewhat contested. There are a range of different definitions of climate litigation, and one of the most influential is what you can see depicted in this image here, which is from two academics, Jackie Peel and Harry Sofsky. So this graphic, which is a bit hard to read, I think, sets out the field into four different types of cases. The smaller circle that you can see here are cases where climate change litigation is a central issue in the case. So an example of that is the agenda litigation. The next circle out describes cases where climate change is not a central issue, but is a peripheral substantive issue. The next circle again refers to cases where climate change is a motivation for the litigation, but is not raised as a substantive claim in the case. So an example of this type of case would be a procedural administrative law challenge to a fossil fuel project like a coal mine. And the final circle refers to cases where there is no specific climate change framing or motivation, but the case has implications for either mitigation or adaptation nonetheless. So an example of this would be a case in relation to forest management practices or permitting. Now, of these categories, academic commentary generally focuses on the first category in the smallest circle. And the definition that we use at the Grantham Research Institute for our databases is as follows. It's that climate change law, policy, or science must be a material issue of law or fact in the case. So this is ultimately quite a narrow and constraining definition, which sets a high bar for inclusion in the databases, which we have used as the basis for preparing this report. So this approach to the definition of climate litigation is something that is not necessarily intuitive for either practitioners or judges. And as part of our survey, we asked a question which partially teased this out. So we asked members to identify climate cases and laws from their jurisdiction. And a clear trend that we observed across the national reports is that the cases and litigation provided by members fell outside of our working definition of climate litigation. So from the 90 cases that were collectively referred to across all of the different survey responses, only 23 of those cases were climate cases as we would define them that weren't already on the database. Some cases included, some reports included cases on air pollution, peat mining, forest felling, and waste disposal. And while these are all very important topics, highly relevant to climate change, we would consider them environmental cases only rather than climate litigation, strictly speaking. And therefore, as part of that outer ring that you can see there. So whether this approach to defining the field is appropriate is something that we would really love your perspective on, because as I said, I don't think it's a particularly intuitive definition. And that's maybe something we can return to in discussion later on. So with that opening, I'll now turn to a summary of part one, where we provide an overview of climate litigation in Europe. Next slide, please, Mara. So I think it's helpful to begin by situating European climate litigation in the global context. The graph that you can see here shows the number of cases filed globally, and the US is in green at the top there. Europe is blue, and then the yellow color is cases in the rest of the world, i.e. not Europe or in the US. As you can see, there's a very large percentage and proportion of US cases, which make up around 2/3 of all of the cases globally. And there are a number of reasons for this. Some of them are methodological. So for example, climate litigation in the US is very well documented. The Sabin Center's database that Kate referred to is very long running and is very well established. So there's a very comprehensive coverage of cases in that jurisdiction. And that's something that's not necessarily replicated in other jurisdictions. Another reason is that the coverage of non-English speaking cases is very limited in the database. So we see a skew towards English speaking jurisdictions or those in the global north. So the takeaway is kind of take these figures with a grain of salt. So next slide, thanks Farah. So this is zooming in on just the blue cases, the European cases over time. And you can see that there's a meaningful increase in litigation from the mid-2000s to the late 2000s, which was driven mostly by the introduction of EU climate policy and legislation, including the EU emissions trading system. And then you can see a spike in recent years after the passage of the Paris Agreement and the success of the agenda decision. Next slide, please, Farah. So this map shows those same figures, but just transposed geographically. And it gives you a sense of some of the countries that are hotspots for climate litigation. So obviously, Germany, France, and the UK and Spain have the most cases. And you can also see there a box of cases for European courts. So there are 60 cases, according to our figures, that have been before the Court of Justice of the European Union. The number there for the European Court of Human Rights is 10, but I've just been reliably informed over lunch that it's actually 12. So we'll fix that up. And given the spread and trends of climate litigation in recent years, we anticipate that most countries will receive cases if they haven't had them already, or an increasing number of cases. Next slide, please, Farah. So I think it's helpful to look at the way in which researchers divide up these cases into three distinct and temporally defined waves. So you'll see on the left hand there a first wave of cases which started in the 1980s and stretched into the 2000s. These cases largely consisted of a small number of administrative law challenges to governments for failing to take into account climate considerations in their decision-making. And this was a lot of what we call non-strategic cases focused on opposing discrete fossil fuel projects. A second wave of cases started in the mid-2000s as public awareness of climate change grew, and we saw a significant increase in climate laws and regulations being introduced, particularly after the implementation of the Kyoto Protocol in 2005. The third wave of climate litigation, which we are currently in, began in 2015 after the signing of the Paris Agreement and the success of strategic cases such as, again, the agenda decision. And this period has been characterized by an incredible diversity of case types brought by a varied range of claimants against a varied range of respondents, increasingly corporations in addition to governments. And in particular, we've seen a lot of successful constitutional and human rights cases in the wake of the landmark agenda decision. So I think it's important to note with this model that these waves are overlapping. So cases that are typical of the first wave of climate litigation are still commonly filed today, for example, to contest new fossil fuel projects. But they'll also be met with different case types and form often complex litigation strategies. And so what this means is that the development of climate litigation in a particular jurisdiction is not necessarily linear. So in a country that doesn't have much climate litigation yet, we could see a new case or a first case from any of these waves. It wouldn't necessarily be a first wave type of case first. And we think that's a particularly relevant concept to keep in mind for those members who come from jurisdictions where climate litigation is more nascent or hasn't really emerged at all yet. I'll just also speak briefly to the parties in litigation across these waves. 75% of cases in Europe have been brought against governments. But in recent years, we've seen a rise in cases against corporations as defendants. So 40% of all of the cases that have been filed against corporations have been since 2020. So there's a clear shift in the litigation strategy of claimants to focus on corporations in particular. And that takes in a range of different case types, such as the greenwashing cases that have been attracting a lot of attention recently. In terms of claimants, only 50% of climate cases are brought by NGOs or individuals, and governments have filed around 15% of cases, with corporations bringing the remaining 30%. And those cases brought by corporations are generally ones that are seeking to contest the parameters of new climate policies and laws. I'll just go to the next slide, please, Farah. So I wanted to briefly mention another way in which climate litigation is understood, and that is by categorizing cases as either strategic or non-strategic. As you can probably imagine, strategic litigation is focused on, is brought by claimants who are attempting to achieve some sort of broader shift in law or policy through the case. And this is often connected to very sophisticated campaigns that are run by NGOs or communities. As you can see from this graph, a large proportion of the cases brought in Europe are actually strategic in nature. So a total of 119 of the 285 cases in Europe are strategic, which is a high proportion compared to the rest of the world. I think it's also important to note that not all strategic cases are pro-climate cases. So as we explain in the report, there's also a category of cases which we call non-climate aligned cases, which seek to delay climate action. So no cases in that category have actually been brought in Europe since 2015, but we anticipate a rise in this type of litigation, particularly with the introduction of new EU legislation on climate change that we've been hearing about today, as corporations look to essentially test the parameters of their obligations. Let's go to the next slide. Thanks, Farrell. So I just wanted to briefly flag one of the things that Grantham has developed this year, which is a taxonomy of different types of strategic cases. There's more detail in the report on each of these strategy types, so I won't go through them, all of them now, but I'll pick out a few. So you're probably all familiar with government framework cases such as Agenda or the recent net zero case in the UK. And these are cases that seek to drive more ambitious national level climate policies or laws. And Europe is a particular hotspot for this type of litigation and really a leader globally when it comes to this case type. Over half of these sorts of cases have been filed in Europe. And so there are 80 cases globally and 39 in Europe. Another increasingly common type of case are corporate framework cases, which are brought against companies to try and reduce their emissions. And another well-known recent example is the Shell decision in the Netherlands from last year. I think a final one I'd pick out there is at the very bottom, and those are compensation cases, which are cases where damages are sought from defendants based on their historical contribution to climate change. Now, of the two cases filed in Europe so far, it's interesting to note that the claimants in both of those cases are located outside of Europe. So in the RWE case, the claimants are in Peru, and in the Holcim cement case, the claimants are in Indonesia. So we think that this indicates the beginning of a new trend of claimants outside of the region targeting Global North companies for compensation. And there's quite a lot of interest in this type of litigation from private litigation funders who see an economic opportunity. Just move on to the next slide. So I'll summarize this first half of the presentation by just briefly talking about the outcomes of climate litigation in Europe. So one of the things that we're quite interested in is that it's obviously very difficult to measure the impact of climate litigation, which is something that hopefully we can again pick up in the discussion. What are the systemic consequences of a case like Agenda? What are the benefits of a strategic case as opposed to a non-strategic case for climate policies or ambition in a country? These are all questions that are quite poorly understood and researchers are starting to turn their attention to. In terms of the outcomes though, this graphic shows you the direct outcomes of climate cases. And as you can see, of the 232 European cases where a judgment has been issued, the majority have cases which have a direct favourable outcome for climate action, which I think is a much higher ratio than people would assume when it comes to this field. But I would note that this should be viewed with caution because a directly favourable outcome for climate action can be a non-climate aligned case, say brought by a corporation that's seeking to delay action on climate. If they lose, that's counted as a favourable outcome, so it's in the green category. So it's a slightly misleading graphic, but I think an interesting one nonetheless. Okay, next slide. Thank you, Farah. So I now just want to turn to a summary of part 2 of our report, which is where we looked at all of your very helpful survey responses, and we analysed that against our data. And we also, in this half of the report, looked at trends in cases before the CJEU and the ECHR, but I won't focus on those courts as much today because there are presentations on each of those courts in the course of this conference. So our approach was to consider the 21 reports and try and draw out common issues from amongst them. And you can see on the slide here 5 specific common issues or points that were raised. So starting with the first one, and that relates to standing. Many of the reports stated that a barrier to climate litigation in their jurisdiction was the difficulty with establishing standing or a legal interest in the case. As the Estonian report pointed out, this is particularly challenging for individual claimants and NGOs, as it's difficult to establish a nexus between their claims and their legal interests. Looking to the case law, standing has also been an issue for corporations. So the wave of cases that emerged in the mid-2000s to late 2000s brought by corporations contesting the parameters of the EU ETS legislation were mostly resolved not in their favour on the basis of them failing to have standing in those cases. I think it's interesting to note, though, that not all of the reports reported difficulties with standing. So the Greek report in particular emphasised that in administrative environmental law cases in that jurisdiction, standing is interpreted broadly. And the UK report stated that the standing to bring judicial review and statutory review claims in the planning court was broad. So this is clearly an important substantive and procedural issue, which is being addressed in different ways before domestic and regional courts across the region. And we anticipate that with time, it's likely that standing will become less of a barrier to climate litigation as the impacts of climate change are felt and as more cases are brought that contest the parameters of standing as an issue. The second issue there is the relationship between established principles, domestic and international environmental law principles, and climate change. And a lot of these were identified in Professor Voigt's excellent presentation earlier today. This was one of the more interesting and slightly cheeky elements of our survey, which is where we asked the members to be forward-looking in identifying legal principles that were relevant to effective climate action. There was not actually a lot of convergence between the different surveys on the types of legal principles and laws that were identified. And we think this possibly reflects the domestic focus of that question. But there were some principles that came up a few times, and I've drawn them out here. So the Polish, Estonian, and Romanian reports referred to the importance of the polluter pays principle, which is obviously a key concept when you're thinking about loss and damage and compensation related cases. Another principle that was cited in the Norwegian and Italian report was the rights of future generations, particularly in the context of the Greenpeace Nordic case, which we'll have a presentation on later in this conference. The Polish and Estonian reports also referred to the importance of the precautionary principle as it is enshrined domestically in those countries. But I think the principle that was cited the most and seemed to be of the greatest importance to respondents was the right to a healthy environment, which again was addressed by Professor Voigt this morning. So as you'll know, this right is widely recognized in over 155 countries and was adopted by the General Assembly earlier this year. But there isn't any recognition of the right in the core international human rights instruments, including the European Convention on Human Rights. So that means that all of the ECHR cases that have been brought under Articles 2 and 8 because there is no freestanding right. Now, much of the discourse on the right to a healthy environment is focused on its expansion. But one of the interesting things to come from the national reports, in particular reports of Portugal, Norway, Spain, and Belgium, was observations around less around recognition of this right and more around the implementation and enforcement of the right domestically. The Spanish and Portuguese reports noted that despite the right being enshrined domestically in the Constitution, there weren't many judgments on the matter, nor were claimants interacting with it in a sufficient way. The Norwegian report carefully analysed the Greenpeace Nordic case and identified that the right has limits in terms of its capacity to be a basis for climate litigation. So given that the right to a healthy environment is adopted in so many European countries, the exact ways in which it may be expanded to address climate change will be really important for the future of climate litigation in Europe. So a third issue that we identified from the reports concerned the central role played by administrative and constitutional cases. So while at least half of the national reports acknowledge that climate cases come before a range of courts, there was nonetheless a very clear emphasis on classic first wave administrative law challenges, often to fossil fuel projects. And similarly, many of the reports mention very high profile constitutional and human rights cases, again, Agenda, the Neubau case in Germany and the Klimaatsak case in Belgium. I think an interesting implication of this emphasis on the more well-known mainstream of climate litigation is that emerging case types concerned with issues like compensation, greenwashing, or say the personal responsibility of company directors does not appear to be particularly well known. And while this is not entirely surprising, we would expect this to potentially change as those cases become more common. A fourth issue that was clear across the reports was the key role that is played by domestic climate laws and EU legislation. Now, across the reports, more than 100 domestic and EU laws were cited. And EU laws were mentioned in 7 of the reports in particular, with the EU ETS directive and the directive on air pollution being the most commonly cited. Kate will come back to the role of EU legislation in particular when we think about future trends of climate litigation in a moment. But I would just note the basic point that domestic climate laws and EU laws catalyze climate litigation. There's often an attempt to fill the gaps left by a perceived lack of policy ambition, which claimants try and pile into. So an example of this is the recent net zero case in the UK, which was a case that challenged the alleged failure of the Secretary of State in terms of executing their obligations under the Climate Change Act. So a fifth and final issue that came across very clearly was the need for specialisation and training in climate litigation, which is somewhat self-explanatory and picks up on a lot of the really excellent points that were made in the presentation immediately before lunch. The reports from Estonia, Spain, Bulgaria, Serbia, and Portugal all emphasise this need for greater training for all of the actors involved in climate litigation, not just judges. And as you can see from the content of the presentations today, this is a very rapidly evolving, factually complex and unevenly dispersed field. And so it's no surprise that there's a call for further training and support. The Estonian and Serbian reports recommended permanent training on climate and environmental law and climate science in particular for judges, while the Bulgarian, Portuguese, and Spanish reports identified the need for well-qualified independent experts as an aid to litigation. And some of the courts also called for specialist environmental courts and tribunals in jurisdictions that don't already have them. So to summarize these common issues that we've identified from across the survey reports, there are obviously a range of substantive, procedural and practical points that have emerged here, which I think collectively have given us a really good snapshot of the types of issues that face the judiciary in making decisions around climate litigation in Europe. So Farah, I'll just go to the next slide, please. Thank you. So as I mentioned, half of this section of the report goes into quite a detailed analysis of cases before the CJ, EU and the ECHR. I won't take up our time today with doing that, but I'll just make a few brief points. The first is that you can see here quite a clear trend towards bringing strategic cases before the ECHR since 2020. So those are the pink cases on the far right-hand corner. There are 12 of these cases that have been brought in that time, and there haven't been any decisions yet. So 3 of the cases have been relinquished to the Grand Chamber, and we can expect a decision at some point in the future. All of these cases have been brought on Article 2 and Article 8 grounds at a minimum, and then also additionally under other articles. What's also interesting here is you can see a drop-off in CJ EU cases at different points. And we have broken up the CJ EU cases into 2 categories here. The green cases are ETS-focused cases, and the blue are non-ETS focused cases. So we haven't had an ETS case in Europe since 2017. And you can also see a drop-off in the use of the CJ EU as a strategic venue for litigation in general. And so this is a point that Kate's going to pick up on, but we don't think that that is the end of the matter when it comes to litigation before the CJ EU. So I'll pass over to Kate to speak about some future trends in climate litigation in Europe.
Oh, perfect. So one of the things that we anticipate is that following the legislative package that was described before lunch and the various efforts of the Commission in multiple different dimensions at the moment, we are likely to see a massive increase in litigation, both before the CJEU and in member states, around the implementation of that legislative package. We're talking about sort of thousands of pages of new laws that will, I think, cause many disputes, both in terms of how the legislation should be interpreted and also what might take place if there are conflicts between some of the new provisions that are being discussed and considered. And we think this will really sort of mirror that kind of increase that Haj showed with litigation in the mid-2000s when the ETS directive and other EU climate policies were first introduced, but will be on a much greater scale, given that there is much more involvement and engagement with this concept of climate change litigation across the board. So I think that's the first important trend that we've identified. The second trend that we think may come into play in more detail is cases that are focused on the personal responsibility of particular individuals, particularly individuals in positions of power. One of the things that came out across some of the national reports was a concern about the way in which climate change litigation might manifest before criminal courts. And we've heard, of course, before lunch about developments with the idea of ecocide. There is a corollary of this, which is seeing the use of sort of cases grounded in shareholder protections to try and challenge the decisions that individuals, particularly the helm of international multinational corporations, might be making, and the degree to which climate risks and interests are being incorporated into those decisions. So that, I think, is an area where there will be additional efforts to bring new cases. And indeed, a couple of days ago, there was a case brought by a group of shareholders supported by NGOs and shareholder activists challenging corporate lobbying efforts. So really a growing area. Another trend that we identified based on the national reports and on sort of cases in the database is an increasing concern with non-carbon dioxide greenhouse gases. So there is a growing awareness among policymakers at the international and in some domestic jurisdictions at the national level about the role that these greenhouse gases play. And many of them they stay in the atmosphere for less time than carbon dioxide, but in the short term, they are much, much more powerful than carbon dioxide in contributing to global warming. And so this is an area which I think will involve quite technical questions, scientific questions, but where we're likely to see more cases being brought. And so a real area where this question about independent experts, about scientific training, and so on, is likely to come to the fore. And then the final issue that we think we'll see in growing is cases that are on the nexus of climate change and biodiversity, which is an issue that many of the previous speakers have highlighted as something really important. And these are likely to really sort of focus on forests and food systems and the way in which agricultural emissions or emissions relating to deforestation, questions about forest management practices will all come into play. We heard from one of the speakers before lunch that many of Europe's forests are turning from carbon sinks into carbon sources. And I think this is an issue that may well end up in disputes before the courts. So those are some of the sort of initial or future issues that we think are likely to manifest in Europe in the coming years, and we'd really be interested in further discussion on them. We also had some recommendations kind of drawing out from different things that were said in the national reports. And we had 4 of these. The first reflects really the survey results and also what we've heard from Justice Antonio Benjamin, from Divya, the speaker from the European Bank on Reconstruction and Development, which is that there is a need for more judicial specialization and training on climate litigation and science. So that was something that came out loud and clear from the reports. The second is a connected point, and we would recommend that judges who are interested in this issue, including sort of colleagues who maybe are not members of forums like this one, should be pointed to and make use of a number of training materials that are currently being developed on this topic. There's a number of interesting materials that have already been developed by the Asian Development Bank, and the IUCN World Commission on Environmental Law has a project that I'm sure Professor Voigt can tell anyone who's interested more about, developing a global handbook for judges on climate change litigation, which is due to be published, I think, in the next 6 months or so. Academic publishing timelines are always subject to change. The third recommendation that we drew out relates to promoting exchange regarding climate change litigation at judicial events. Obviously, that's the subject matter of today and tomorrow's discussions, but we would sort of recommend also thinking about how can you introduce these topics into discussions with colleagues who are perhaps less engaged on the environmental agenda more generally. The fourth recommendation that we propose really for the European Forum to take up, perhaps rather than for its individual members, is continuing to connect with other judicial institutions. And of course, we have the Global Judicial Institute on the Environment very well represented here. So great to see that already being put into practice. And then our final recommendation is that we do see some members of the judicial community engaging in the academic scholarship on climate change. And those contributions have been really among the best and the most useful. And I think it's really, really crucial that we see judges continuing to engage in this way, because otherwise this perhaps slight gap between what the academic literature is concerned with and the reality that judges and practitioners are faced with on a daily basis might continue to widen. So really, really important to have that kind of broad engagement with academic research. So I think that's all from now, and we're looking forward to a bit of a further discussion.
Merci pour la présentation des résultats du questionnaire. Comme dans le passé, notre idée est, si vous êtes d'accord, qu'on vous laisse une période d'une dizaine de jours pour encore revoir votre rapport, et si vous êtes d'accord, après cette période-là, de le mettre sur notre site web ensemble avec le rapport intégré. Donc, je pense que le rapport a été envoyé à tous les membres. Et donc, s'il y a des commentaires à faire, et peut-être aussi le faire dans une période de dizaines de jours, afin qu'on peut finaliser ce matériel. Maintenant, la parole est à la salle pour des commentaires, des questions, des réponses. Est-ce qu'il y a une question online? OK. So, Ian, are you there?
I am. Yes,
Yes.
I am, Luke.
You can speak.
Thank you very much indeed. Well, I apologize, first of all, for being a change to the advertised program. But Farah has just asked me to say a word or two about a case that Haj has referenced during the course of the last fascinating presentation in relation to climate change cases. And that is a case which was heard in our High Court here in London during the course of the summer. And Farah, I don't know whether it's possible for you to put up the presentation which I sent to you. Excellent. Thank you very much indeed. So this is the net zero case that Haj was referring to, brought by Friends of the Earth and Client Earth. Could we have the next slide, please? So as some of you may know, the framework for tackling climate change in the UK was established by the Climate Change Act 2008, recently amended following the Paris Agreement to require meeting net zero by 2050. And the framework of the Act provides a means of setting carbon budgets in 5-year periods in order to achieve that end, the latest being Carbon Budget 6 for the period 2033 to 2037. And I think many lawyers had thought that this act was in itself enough of a guarantee to ensure that climate change issues would not necessarily be troubling the court directly, it being the responsibility of the executive to set the policy to meet these carbon budgets and for them to then ensure that net zero was met. Two particular sections of the 2008 Act came into sharp focus, however, in this case. Section 13, the section which requires the Secretary of State to prepare policies and proposals to meet a carbon budget, and Section 14, a procedural section requiring the publication of a report. Could we have the next slide, please? So the issues in the case. Firstly, the briefing that was made to the Secretary of State, to the Minister, in relation to Section 13, provided that he could be sure that about 95% of the necessary emission reductions required for Carbon Budget 6 would be achieved, but the briefing didn't provide any specific reduction as to which policies might achieve which reductions. There was some modelling which was the justification for this, but it wasn't contained in the briefing. And there was some confusion in the way in which the case was presented. It appears that from the judgment that it was only when the case was being heard in court that it became clear that that going from 95% to 100% reduction in emissions, that the complete achievement of the carbon budget was actually, in the final analysis, simply a matter of judgment. Those concerns founded the case before the court, and if we could have the next slide, you'll see the judge's conclusions. And my colleague, Mr. Justice David Holgate, concluded that the failure to provide information in relation to the individual policies and their contribution to achieving the 95% reduction was a breach of Section 13 of the Act. These were matters the Minister needed to be informed about in order to reach a sensible judgment about whether or not the carbon budget would be achieved. Secondly, in relation to achieving the final 5%, where there was no quantified policy at all, that there was a further failure or breach in relation to Section 13 because the Minister required information about how that judgment of the additional 5% had been made. Were there other calculations of which he was unaware? What unquantified policies were going to be developed? And both of these concerns, the absence of detail in relation to the 95% and the absence of an understanding of the justification for the final 5%, also gave rise to breaches of the reporting duty, the duty to make a report of the decision under Section 14 of the 2008 Act. And so for those reasons, the net zero strategy, which was the policy designed to meet Carbon Budget 6, was quashed, was struck down, and the Minister will have to have another go. Interestingly, there was a third basis for the challenge, which related to the statutory interpretation of the Act. It was contended by the claimants that a more strict or broader interpretation of the Climate Change Act should be undertaken, and was compelled as a result of the Urgenda case and the application of the Human Rights Act 1998, as well as the European Convention on Human Rights. But the judge was not satisfied that that approach was required as a consequence of the UK's approach to the decisions of the European Court of Human Rights. If we could have, therefore, the last slide, please, Farah. What the case illustrates is, from our jurisdiction's perspective, a fairly conventional approach to a public law case. The Climate Change Act provided a code, a framework to meet the requirements of net zero, but how that was to be achieved depended upon policies to be arrived upon by the executive. However, the duties under that act, it is now clear, are subject to the court's interpretation and construction, applying usual principles of how to understand and interpret a statute. And the discharge of those duties may involve taking account of considerations that are so obviously material that they must be taken into account in order to comply lawfully with the duties as properly understood. And unless those obviously material considerations are taken into account and presented to the minister in order when he or she is reaching their decision, then the duty will not have been complied with. And all of those principles provided a remedy for the claimants without the need for the Urgenda case or the associated human rights arguments to be acceded to. They were not necessary for the purposes of the decision. My understanding is that the case is not going to be appealed further. And so it is a final position so far as that litigation is concerned. And if anyone is interested to read the judgment, I passed a copy to Farah, who I'm sure would forward it on if you would like to have a look at it. It is, however, quite a lengthy piece of work. Thank you very much.
So thank you. We are already on the next item. I have the impression, because when we compare this case with the Urgenda case, of course, the starting situation is different. In the UK, there is a national act saying we should have net zero emissions in 2050. And we should work together, while in the Netherlands, there was no such a national act, and only let's say the European Union obligations of that time. But let's still take, before going to Urgenda, some time for questions. Yes, Robert.
Yes, thank you. Robert Carnworth from the UK. Could I just say a word about that case you just heard about? I think it's a very interesting case. It's particularly important since half an hour ago it was announced we've got a new Prime Minister in my country. We don't yet know what his environmental policies are, but I think it's very important we have this strong act, Climate Change Act, but on its face, I think Ian didn't say that, the reporting is to Parliament, and so the sort of structure is that the minister must set out his policies and report them to Parliament, and so one might have thought, well, it's for Parliament to oversee it. But what Mr. Justice Holgate, excellent judge, my former pupil, has said is that no, the policies must be set out in the Act, and they must say how you're going to achieve your goals and how you're going to do it sector by sector. And he said they must produce a new report by, I think, March next year. Now, that's going to be something which the new Prime Minister and his government are going to have to grapple with, because there's been quite a lot of pressure to sort of move much more towards fossil fuels away from our very strict policies. They're going to find that very difficult, I think. And it's also, I think, going to be very important in the run-up to COP27 in Egypt, that we, I think, are going to be constrained within a fairly tight framework. So I hope and think that it's a very good example of how the courts can back up government policy by providing legislation with real teeth. So watch this space.
Thank you. Are there further comments or questions for the moment? If not, then we move to the next part of the day. And now we will have 5 different presentations on national and European case law. And I'm happy to present to you Judge Koos van den Berg, who is a judge with the District Court of Amsterdam. But if I'm not mistaken, he was involved in the Urgenda case in another life when he was still in practice, in private practice. So the floor is yours.
Thank you very much. Thank you for organizing this wonderful conference, and thank you for your invitation. I really feel privileged to be invited. Yes, I'm a judge at the Court of Appeal in Amsterdam, but I was until April 1st, 2021, I was a lawyer, and I was leading counsel for Urgenda in the Urgenda case. What I try to go quite fast by the slides, so warning. I'm trying to guide you a bit through the architecture of the Urgenda case. Well, this is what is at stake, not according to Urgenda, but according to science. The planet as we know it is in the balance. And next slide, please. And obviously, this is what is at stake for the Netherlands, especially, and it's easy to see why the right to life and the right to family life and home come into play. So, next slide, please. The consequence, these 2 bullet points, I think, are fundamental, and you should keep them in the back of your head, because I think they're important for the thrust of the Urgenda case. The first notion is dangerous climate change must be prevented. And the second one is, well, if you want to prevent it, you must get your emissions to 0. But before climate change becomes dangerous, which means that the next, the overarching theme for the Urgenda case was this. And this is what I literally, in almost all 3 instances, started by saying, because I wanted to make the judges clear that we knew what we were asking, what Urgenda was asking, was unheard of. It was unheard of. But we wanted to make clear to the judges that we knew it was unheard of, but also that we thought it was justified by the consequences of doing nothing or doing not enough. So we asked them to take note of the facts, and we put a hell of a job in presenting the facts and the climate science, so the judges could read the reports and understand the reports of the IPCC. Well, this is the next one is what Urgenda submitted to the court. This is basically what the Urgenda case is all about. And for the concept of unlawful, Urgenda relied on tort law and infringement of human rights. Those were the 2 pillars for the claim. Well, there, as you can see, there were 3 judgments. In the next slide. The district court granted the court order and relied on tort law and said agenda is not a human being, so it cannot rely on human rights. The Court of Appeal thought differently because and relied on the Human Rights Convention, Articles 2 and 8. And from a constitutional point of view, this is a much stronger foundation for the court order with respect to the separation of powers, because in the Netherlands, the Human Rights Convention is of the highest ranking, much higher than the Dutch Constitution. Well, next slide is for some chronology. And maybe you know this already, but the Climate Convention of the United Nations was about stabilizing concentrations of greenhouse gases in the atmosphere at a level that would prevent dangerous man-made climate change. And you will note that dangerous, what is it? It's not defined, there's no definition yet. And to do so fast enough to allow ecosystems to adapt, which means that the warming must slow down because our ecosystems are not adapted to a very fast temperature rise. So there's a time element in this definition as well. Well, then in 2007, there's the fourth assessment report of the IPCC. And well, they found that, well, if you want to stabilize these concentrations, you must be practically reduce the emissions to zero. Because carbon dioxide especially does not decompose. It's a stable chemical substance, so it does not disappear, which means that all the carbon dioxide that we have been dumping since the Industrial Revolution is still there. And so the concentration rises and rises. And in this fifth assessment report, they say, well, there's a linear relationship between concentration and warming. Warming increases proportionally to the total amount of carbon dioxide in the air. And it also said the risks are more severe than previously thought. Well, the next slide is the chronology. There's the agenda case. And then there's the Paris Agreement. One of the important things of the Paris Agreement is that it held a definition of what is now a dangerous man-made climate change, as you can see. And then there were the other two judgments. The next sheet is just for your information. Where are we now? Well, the emissions are still rising, the global emissions. So it's not reducing, it's rising. So atmospheric concentration is rising. It's 410 parts per million now. Global warming accelerating. It's now almost 0.2 degrees Celsius per decade. So if you want to stay below 1.5, we've got 2 decades. Sea level rise is also accelerating. And in the graph on the right, you see there indeed is a linear relation between carbon dioxide concentration, that's the red line, and temperature. And it's also good to note that this steep incline in temperature has never been seen for at least 1 million years. So this is not what our ecosystems are fit for. Next slide, please. Well, as I said, agenda relied on tort law and on the Human Rights Convention. Well, in the Netherlands, tort law recognizes 3 categories of wrongful acts. The first one didn't apply because in the Netherlands, there was not a statute or a law that made any climate target or concentration target. The second one also didn't apply because the climate is no one's property and no one owns the atmosphere. So we had to rely on the third category. It's a violation of the unwritten standards of care that is due in society. So that's, well, basically it is, you cannot behave in a way that we don't accept in our society, or rather in a society that we want to be, which makes a difference. Well, it's easy to understand why the state would be responsible for its own emissions, but it's maybe less so why it would be responsible for the emissions of everyone else. Is that an act of the state as well? Well, the constitution in the Netherlands is not actionable, but it does say something about this. And well, we argued that with regulation and permits and financial tools, the state indeed has effective control over everything which happens on its territory, so also over its emissions. And in entering international negotiations and in the climate convention, the state has assumed responsibility for all emissions on its territory. So the state is responsible, and actually the state did not contest this, although they said, well, yes, maybe we're responsible, but not towards agenda, but towards other states. European Convention, we relied on the Articles 2 and 8. I think you know what this is. The same question arises there. Well, these are positive obligations, which means that the state must not merely refrain from interference with these rights in its own dealings with its citizens, but it has an obligation to actively secure and protect these rights of its citizens. And that may include from protection from environmental hazards as well, and pollution, insofar as they may seriously affect the enjoyment of these rights. So it's still anthropocentric. It's not a guarantee for a healthy climate or a healthy environment, but as soon as it affects the living of people, then it becomes something which falls within the scope of the Human Rights Convention. And of course, there's effective control. Next slide, please. Well, this is the causation requirement, and before agenda case, doctrine said that the causation requirement would be an unsurmountable barrier for climate liability. Well, in climate litigations, causation requirement comes down to, it isn't me, I'm not the cause of the climate problem. So let's address that. The next slide shows what the state was arguing. First of all, Dutch emissions are insignificant on the global scale. They do not cause climate change. I'm not responsible for climate change. So the requirement of causation is not met. And it follows that if you want to reduce Dutch emissions, climate change will happen anyway. So it's not an effective remedy for the protection that agenda is seeking. So agenda does not have sufficient interest for the claim. The red, what you see in red there is basically what the state said. The state said, well, we must negotiate a global solution, and individual responsibility shouldn't be there. In fact, it would interfere with this with my political position in the negotiations. You're undermining my negotiation position. But this was basically what they were saying. Well, before I turn into the reasoning of the courts on these points, to the next slide, please. There's something that I think you should bear in mind. First of all, let's repeat, we must go to zero emissions. So there is no such thing as an insignificant, irrelevant emission, and also not an irrelevant emission reduction. They do matter, because every emission adds more carbon dioxide to the atmosphere, which never disappears, and adds warming, big emissions, much warming, small emissions, small warming, but if you want to stop warming, zero emissions. Well, the second one, I think judges are familiar with that one. The causation requirement is not very useful in cases with multiple causes, and most sophisticated legal systems have found alternative approaches. And the third thing that I want to say is the causation is not very relevant for an injunction to prevent harm. And maybe let me reflect on something that Justice said, that Herman Benjamin said. He said, judges are always looking back. Well, with respect to the agenda case, I'd like to propose a different perspective. I would say that the purpose of liability law is to protect rights and protect legitimate interests. And that means compensating for violations that happened in the past, but also, and preferably, preventing imminent violations of these rights. And that is what the agenda case was all about, preventing further damage. And the causation takes on quite a different color if you in preventive action, because then if you say, I want protection from potential harm, then it's quite a different question than saying, well, that harm is dangerous and it caused, that activity is dangerous and it caused my harm. It takes on a different color, which is important. I think one of the reasons we did not have very much problem with the causation requirements. Well, the next, thank you very much. This is the reasoning, the line of reasoning of the Supreme Court on the individual responsibility of the state and causation. First refers to the no harm principle. Sorry, no, this, the previous one, please. Yes, yes. Which is, maybe you know it, but this is from about 1915, the Trail Smelter case. And the outcome was that every state is individually responsible for damage and harm that is caused by activities from its territory. And the Climate Convention says in its preamble very clear, this treaty builds on the no harm principle, which means individual responsibility of states. And Article 10 speaks of common but differentiated responsibilities, the CBDR principle, which means that the responsibilities are individualized. And Article 4 of the Paris Agreement, you can read for yourself, all parties are required individually to pursue domestic measures aiming to achieve the objective of their national determined contributions. And there's also the draft articles on responsibility of states. And the bold letters are, I think, interesting. This is because this is exactly what the state had, the Supreme Court had ruled in a famous case in the Netherlands in 1988, the Mince de Potage. And it was exactly this. And so the Supreme Court said, well, many countries have corresponding rules in the liability system. So next slide, thank you. This is the reasoning of the Supreme Court. It says that there's individual state responsibility for every state for their share in contributing to climate change. Yes, thank you. Well, the interesting thing is that the Supreme Court said, well, the defense that a state does not have to take responsibility because other countries do not comply with their responsibility, that defense cannot be accepted. And also the defense that your own greenhouse gas emissions are very small and are irrelevant, make little difference and won't help. Also, that defense can also not be accepted because if you would accept this defense, it would mean that every country could back out and point to others and say, I'm not the problem. If, on the other hand, this defense is ruled out, it means that every country can individually and effectively be held to account for its own courts, for its shares of emissions. And being that's the case, it means there's a far better chance that all countries will actually make their contributions. And you must understand this to the background of that this top-down, we need a global agreement, has been tried since 1992, and it just didn't work. There was a deadlock, it was a stalemate. That's why the Paris Agreement explicitly went for the individual responsibility. So the conclusion of this was the state is individually responsible for its emissions, to reduce them to zero and do it fast enough. The Supreme Court also said in the next slide something about insignificant. Well, this, you heard this all before already. Must be zero. The Supreme Court made explicit reference to the Supreme Court of the USA in the Massachusetts EPA case. And this line of reasoning, which you can read here, is almost exactly the same as what the USA Supreme Court said. And the USA Supreme Court said something else, which I particularly like. I don't know why, but I'll give it to you. It said, small incremental steps must also comply with the law, which I think is good to keep in the back of your mind. So, individual responsibility to do enough, and that applies to even small emissions. Let's go to the legal grounds that agenda relied on. First of all, the unwritten standards of care that is due in society. In short, it is, you must behave properly, you must do what is appropriate, you must do what is responsible. And this resembles very much the way that the Articles 2 and 8 of the Human Rights Convention operate. It's also comes down to the state must do what is appropriate, diligent, responsible for it to do, and it must be able to explain and justify the sufficiency of its actions, which is important. So we've now come to two legal grounds, but in fact, one standard of care, what is appropriate. So what is appropriate? Well, the IPCC report of 2007 made clear that emissions must be drastically reduced. In the report, there was a box 13.7, and it says, well, we don't know yet what the governments of the planet will choose as their concentration to stabilize on. But if you choose to stabilize on a concentration that will keep global warming below 2, and if you wish to do so in a way that's fair and equitable, according to most approaches, it's common but differentiated responsibilities, then the developed industrialized nations as a group must come to this reduction. And this is the first time you see this 25–40% mentioned, and this is where Agenda derived her claim on. It's based on this percentage. Well, that was was in the scientific report, but that's just a suggestion. But the parties to the Climate Convention in their 2007 meeting, they took note of this and they agreed, well, emissions must be substantially reduced. And they explicitly refer to box 13.7. And to the best of my knowledge, this is the only time ever that a specific passage or box in the IPC report was referred to in a COP decision. 3 years later, in the COP decision of Cancun, the parties agree that global warming must be kept below 2 degrees. And they are therefore urged to reduce emissions as is suggested in AR4. So this is a reference made to the 25–40%. And the parties of the Kyoto Protocol, which was in parallel, agreed that they should, those are the industrialized nations, they agreed that they should reduce their emissions with this 25–40%. And these decisions were referred to in every other COP that happened next. And always we must urgently do more, we must do better. Well, you must realize the most COP decisions, I think all of these were made unanimous, but they are not legally binding. But it means there's a very, very strong political commitment. They are not legally binding. Nonetheless, the EU decided, on the next sheet, to go for 20% reduction, acknowledged that it was insufficient because it did not meet 25, but it said, we'll do 30% if other nations will commit to comparable efforts, the level playing field argument. Well, some countries said this is clearly not insufficient. We are doing nationally setting high goals. Netherlands was one of those. We choose for a 30% reduction in 2020 because anything less is not a credible climate policy. And you will find this in all the 3 judgments, as you may understand why. The newly elected government in 2011 abandoned this target, and not because the climate science had changed, but they didn't want to. Well, this is the reasoning of the Dutch courts in the next sheet. First, there's the Climate Convention. We must prevent dangerous climate change. Article 3, every party has to put in efforts, but some must put in more efforts than others. And the industrialized nations like the Netherlands with high national emissions, high emissions per capita, long history of dumping in the atmosphere, and technical capabilities, well organized, financial strong, we must take the lead. And building on these treaty obligations and building on scientific findings, there's a strong political consensus emerging worldwide that 25–40% to 2020 is what the developed countries should do. So the courts find this is the standard of care. This is what is appropriate. This is what is responsible to do. On the next sheet, you'll see how the state responded. He said, well, Agenda is not a state and cannot rely on these treaties. And 25–40%, yeah, it's an IPC report. It's just a suggestion, and the COP decisions, and so are all not legally binding. And the court said, well, true, but that does not mean that they are irrelevant. They reflect a global consensus on a standard of care, a reference point, a measure for what the developed state should do to fulfill its responsibility. You can compare it with the code of conduct in the liability law. Next one, please. I'm not going to read it to you. I do have it here, but the Supreme Court refers to a decision of the Human Rights Court. about the common, how to interpret and understand the obligations of the Human Rights Convention. It's the common ground method. It says you can use science, you can use specialized international instruments, you can political decisions, you can practices of national states. They can be used, they reflect a consensus, a common ground of what should be done. So they can be used to interpret and understand what the obligations of the convention require. Next bullet, you can read it. This is the reasoning of the Supreme Court. And I think the construction, I think, to summarize it, is that you could say, because the tort law in the Netherlands is binding and the Human Rights Convention is binding, but the standard of care is not directly binding. So I think it's good to summarize. You shall do what is responsible, and that should be 25 or 40%, and comply or explain and justify. Well, this is what the Supreme Court said. The state was clear. The next sheet. No, sorry, I think the two previous. I'm not here yet. Even this previous. Yes, this is what the court said in agenda about what is appropriate and comply or explain. And personally, I think this sentence, the state has not provided any insight into which measures it intends to take in the coming years, let alone why these measures, in spite of the above, would be both practically feasible and sufficient. That might well be, in my opinion, the future of climate change litigation, because the responsibility, what the Supreme Court does here is lay the responsibility for climate change flat by the government. But you must show what you're going to do. It's not, oh, we're going to do it later. No. Tell me what you intend to do, and tell me how you're going to do it, and tell me it is sufficient and you have the money for it. Show it. And because the dangers are of climate change are so severe, I think judges should be very, very strict in this and not let them easily get away with it. But then I think that would be the right thing, and it could well be the future of climate change litigation, held to hold governments to account. Well, the next, thank you. Well, we're talking about 25, 40% all the time. When the judges said, well, 25 seems to be the absolute minimum if you cannot explain and justify getting lower than that. 40% is probably better and preferable, maybe from a scientific point even necessary, but 25% is the minimum that the law requires, and doing more is a political question, is not for the courts to decide. And this is the reasoning, more elaborate, of the Supreme Court on this topic. The district court, I've never seen, I've never seen decisions of judges in the Netherlands that were went so deep into the subject of separation of powers, especially the district court put in a lot of effort there, but also the Supreme Court did it. Supreme Court, I think, was a bit easier for the Supreme Court because that decision relied on the Human Rights Convention. But it said, yes, well, the climate policy is a thing for the political branches, and a wide margin of discretion must be allowed. But even the widest margin of discretion for policy making is bound and restricted by the law. Doing more than what the law requires is a political question, but the courts must step in and uphold the law if the absolute minimum standard of care established by the courts in their interpretation of the law is not complied with. And the district court also said, because the state said, yes, but the government has a democratic legitimation. And the district court said, but I have a democratic legitimation as well, because parliament, the representatives of the people, make the laws, and I uphold the law. And the government, if the government doesn't like the law, the government can change the law. But the government can change the law, but the government cannot break the law. And I say what the law is until the law is changed. So the Supreme Court said the courts have found that it's unlawful not to reduce at least 25%, and agenda has sufficient interest and is entitled to an effective remedy. The next sheet is more or less the concluding remarks of the Supreme Court. And the next sheet. It's my thank you to you all.
Merci. Je pense que c'est le temps pour le pause café. Donc, on va continuer nos présentations de différentes affaires après le pause café. Et il y a à la fin discussion sur toutes les présentations de cet après-midi. Merci. Et on va essayer de reprendre dans 20 minutes. Je propose que l'on continue nos travaux et je suis très heureux qu'on a parmi nous l'ancien président de la Cour suprême d'Irlande, Frank Clark, who will speak, il va nous présenter l'affaire des amis d'Irlande et contre l'Irlande. Ça, c'est un peu curieux. Mais ce sont les amis de l'environnement d'Irlande qui avaient introduit une affaire devant d'abord la Cour High Court et puis devant la Cour suprême d'Irlande. So, please, Frank, you have the floor.
Hello. Thank you very much for inviting me to speak here about l'affaire Les Amis d'Environnement d'Irlande. One interesting preliminary observation, I think, is the extent to which there has been cross-citation between many of the courts in the judgments which we are considering here today. And that's perhaps a particularly interesting fact, given that the legal basis for many of those cases was quite different. As we've just heard, where gender was based on either tort law or the Convention on Human Rights. As you're about to hear, the Irish case was based on Irish legislation, which had no parallel in the Netherlands, but had something quite similar in the United Kingdom, which led to the judgment which we've also heard of. And then the judgment of the Bundesverfassungsgericht in Neubar was based on a sort of intergenerational equality argument, which is again a very different legal basis. So it is interesting that notwithstanding the fact that those legal bases were quite different in all those cases, the courts found useful commentary in each other's judgment. We refer to, and much of the subsequent judgments across Europe refer to agenda. Our judgment in FIE was referred to by the German Constitutional Court in Neubar, and also by the High Court of England and Wales in the Net Zero case. And perhaps it's worth reflecting on why that's so. The underlying, I suppose, science is the same, the world is the same, no matter what political boundaries there may be. And therefore, the problem which is being addressed is the same. But equally, lawyers and those having to bring cases have to try and fit that problem into the legal framework which they're given in their national states. But also perhaps allowing courts to borrow slightly from the approach in other jurisdictions gives some latitude for the sort of expansion of jurisdiction which is necessary where an entirely new area is being considered and developed. And it's always useful within the boundaries of what's permitted within a national legal order to consider what has been done elsewhere and apply it to the extent that it's possible. With that in mind, I think it is perhaps useful just to start by making a couple of preliminary points about the legal structure of the case that was brought in Ireland. As a common law Supreme Court, typical of common law Supreme Courts, we are a court of everything. We're an administrative court, we're a constitutional court, we're an ordinary Supreme Court. So questions about competence don't arise in our case. Secondly, we're a court of appeal in all cases, and this case in particular started in the High Court, which is the senior first instance court. It bypassed through a permissible procedure our Court of Appeal. There's a form of appeal called a leapfrog appeal, where the case can leapfrog over the Court of Appeal straight to the Supreme Court, where it's important and urgent that with the permission of the Supreme Court, that happened in this case. So there was a High Court hearing followed by an appeal to the Supreme Court. The facts, the science was explored to some extent in the High Court, but was not the subject of any significant controversy between the NGO, Friends of the Irish Environment, and the government. So the Supreme Court was presented with more or less an agreed set of scientific facts on which to base its legal argument. And finally, it's perhaps important just to make a couple of points about the legal order in Ireland that are necessary to understand how this case arose. Firstly, unlike the position that we've heard of in the Netherlands, international treaties, including the Convention on Human Rights, are not part of the domestic law of Ireland. The Irish Constitution expressly says that international treaties do not form part of Irish domestic law unless enacted by the Parliament. There's an exception introduced on joining the EU, which actually gives full primacy to EU law. So we have a very strong recognition of EU law, but a very weak recognition of all other international law. And that perhaps colored the way in which the case was brought. And I suspect clever lawyers considering how to bring challenges do have to work out how best to structure the case within the legal order in which that case is being brought. The case involved a number of different strands, but the strand which succeeded and the one on which I would comment most thoroughly was one which was not dissimilar to the issue which subsequently arose in the High Court of England and Wales, which judgment actually cited our judgment quite a bit, because the legislation in Ireland and the legislation in the United Kingdom was not the same, but it had certain similarities. And therefore, what we had said seemed to the High Court of England and Wales to be of some relevance, and I think persuasive relevance to some extent to their decision. There was also a rights-based argument relying both on the convention, largely the same type of arguments that were made in the Netherlands in Agenda, and also based on similar rights said to exist in the Irish Constitution. And I'll briefly deal with those. They weren't really dealt with in great detail because they were unnecessary in the light of the fact that the court concluded on the statutory argument that the government's plan had to be quashed. Essentially, the argument that succeeded was based on the provisions of the 2015 Irish Climate Act. And that act introduced into law requirements on the government within 18 months to produce a plan designed to meet what was called the National Transitional Objective, which was essentially the Paris Accord objective of having, didn't quite describe it as net zero, but something akin to net zero by 2050. And therefore, that became a legal objective enshrined in legislation in Ireland. The government was required to produce a plan within 18 months, but which was to be reviewed not more than every 5 years during that period. And that led to one of the debates in the case, which I'll just come back to in a moment. Secondly, the plan did require a significant element of public participation. which again the court found important, in that the relevant minister, the Minister for the Environment, was required to produce a plan, publish it, and engage in a period of public consultation about the plan. And then the plan went for formal approval by the government as a whole. And the court took the view that that was an important element of the overall structure of the Act, which impacted on its assessment. Thirdly, the plan was required, in the words of the Act, to specify, we took the view that meant to be specific about, precisely how the national transitional objective was going to be achieved by 2050. And a lot of the real debate on the key issue turned on just how specific did it have to be, or how waffly would it be allowed be from the government's perspective, how aspirational it might be. And fourthly, and perhaps equally importantly, I think, the legislation required that the plan also address on a sector-by-sector basis how the NTO, National Transitional Objective, was going to be achieved. So it wasn't sufficient just to say we'll reduce by X% by that date and Y% by that date. It had to go into each sector. And that, I think, is perhaps where one of the great difficulties arises. There are a lot of people in a lot of countries, I suspect, who are all in favor of very important measures being introduced to ensure that we meet the Paris Accord, but they are a little less sure about who should bear the burden of meeting those requirements. The phrase NIMBY, not in my backyard, springs to mind in that context. Everyone thinks that the burden should fall on some other sector, which won't affect them quite as much as everyone else. And therefore, I suppose, looking at it from a political point of view, the real difficulty for the government was in having to be that specific and say, agriculture is going to have to take that much of a burden. Farmers get annoyed. Transport is going to have to take that much of a burden. Others get annoyed. So they were the key elements of the legislation. The first argument, interestingly echoing something that was mentioned by Antonio this morning, turned on the question of justiciability. The issue, as is frequently raised by government, is this is policy. It's none of your business. It's not for the courts to be getting excited about these things. You have the right to vote like everyone else, but you don't have any extra rights just because you happen to be a judge. In a phrase set out in the judgment, I think the court dealt with that fairly succinctly by saying what might have been policy became law as soon as the 2015 Act was put in place. The Parliament chose to make a law, it then became law. Government, like everyone else, is obliged to comply with the law. And whatever arguments there might have been prior to the 2015 Act about this being purely policy and not a matter for the courts disappeared in the court's view at that stage. So the government lost fairly roundly on that. The next question, and perhaps the most important question of law that came up, was the issue of just how specific did the Act have to be. And in that context, there was a significant debate about this 5-year review of the Act. Some had thought initially, and I think there was an element of this in the argument of the government, that what was really required were a series of 5-year plans. So you produced one 5-year plan, and when that was over, you produced another 5-year plan. But the court took the view on the reading of the Act. I think it was fairly clear when analysed carefully that that was not what was required. What was required from the beginning was a plan all the way out to 2050. But that the purpose of the 5-year review was an understanding that the technology, science, understanding might develop, probably would develop, that it might well be that measures that were thought to be likely to improve things by a certain amount might turn out to actually be better than that, or might turn out to be worse than that. And that therefore, as knowledge developed and technology and science developed, it would be reasonable to adjust the plan. And the court therefore accepted that the specificity or detail or precision of exactly what was going to happen between, say, 2040 and 2050 might legitimately be less, but that was not a reason for the court, for the government not setting out its best estimate as of today about what it intended to do right out to 2050. on the understanding that that might be adjusted. And the court specifically said in a passage which I think was cited in the judgment in the net zero case in the UK, that the fact that it mightn't be possible, for example, to tell with great precision the extent to which carbon extraction might be useful between 2040 and 2050 was not a reason not to give the best estimate today, on the understanding that that might have to be adjusted. And if it turned out that the technology wasn't as useful as might be hoped, then something else might have to be done. If the technology was better than might be hoped, then there could be adjustments elsewhere. So that's the first element of the standard which the court felt had to be applied, that there had to be a plan right out to 2050 that was a realistic attempt to say how we're going to achieve the NTO by that date. The second element was based on the public participation element of the statutory scheme to which I've made reference. And the court felt that the standard of detail that was required was one which would allow a reasonable member of the public involved in that process to form a judgment about both whether they felt that the plan was realistic to achieve the ends that it was required to achieve, and secondly, whether the balance of the sharing of the burden of meeting those objectives was fair, as in between all aspects. And the court went so far as to say, it didn't quite say that people could vote accordingly, but it said if the plan needed to be specific enough that if it mattered to people, they would know enough so that they could vote at the next election, either in favor of the government that produced that plan if they felt it was good, or to form a new government if they felt the plan was inadequate in some respect. So they were the standards that the court identified in the legislation as being required by law, sufficient detail for an ordinary, informed and interested member of the public to know what the plan said and form a reasonable judgment on it. And also that the plan needed to have enough detail that could reasonably be required right out to 2050, allowing for the fact that the further out you went, perhaps the detail mightn't be quite so great. And against that standard, the court came to the view that the plan fell well short of the requirements necessary to do just that. There were a lot of aspirational things in the plan which are quoted in the judgment, and I've sent a link to the judgment if anyone wants to read it in detail. But there were a lot of things about there would be further research into this, further consideration will have to be given to that, all sort of woolly thinking statements, which were all very nice, but didn't really give any great detail about how the plan was actually going to achieve the ends. And the assessment of the court on that basis was that the plan was unlawful because the legislation required a more detailed account, a more specific account of how the national transitional objective was to be met, and that it had failed to do so. And on that basis, the claimants, the Friends of the Irish Environment, were successful in the case. There are a few minor additional points that I'd make about the judgment. There were, as I mentioned, rights-based arguments put forward both under the Convention and under the Irish Constitution. The court didn't deal with the Convention arguments because it felt it was A, unnecessary, and B, the court took the view that the NGO didn't have standing to raise those arguments. The constitutional issue became somewhat caught up in what has been a major debate internally in Ireland about how you go about dealing with rights that are not expressly stated in the Constitution. Going back to the 1960s, the Supreme Court had identified what came initially to be known as unenumerated rights, i.e. ones that you can't find written in the Constitution, but which the court felt were nonetheless ones recognized. Some people, including myself, felt that the term unenumerated created the danger that judges were simply being asked to make up rights. Put them in if you think they're a good idea, even though there's no sign of them in the Constitution. And this was an opportunity perhaps to redefine that area and to state that rights could be considered to be derived rights, where there are things in the Constitution, either the rights that are formally recognized, the structure of the Constitution, which provides for democratic institutions, some of the values that are referred to in, for example, the preamble, reference to human dignity, but that there should be some route from the text of the Constitution into a right being recognized, which isn't specifically there. It was emphasized that this was not a narrow textual approach, but nonetheless, that there couldn't be a sort of a freestanding invention of a right by the court. And I think that's perhaps valuable in one, and it led to the court being skeptical about the way one High Court judge had described environmental rights, while the court recognized that it didn't rule out the possibility that in an appropriate case, constitutional issues might be relevant in environmental matters. But it also perhaps is based on something I think it is always important to keep in mind, and that is it's only useful in the solution of problems if we live in a society where, by and large, what apex courts decide are obeyed by government. And if we reach a stage where governments can, in practice, ignore what courts do, then we've devalued the whole system of rights-based litigation. It only works because the Irish government has done something about environmental matters, which I'll come back to in my conclusion. And therefore, I think courts need to be a little bit careful about overreach, because one of the consequences of overreach may be that they lose the support of the public, which is necessary to retain their ability to actually achieve the ends that people seek to achieve in litigation. And we've seen even within developed countries within the European Union, a tendency for some governments to begin not to be totally prepared to accept the judgments of courts. I think that's a dangerous development and one we always need to be careful about. One of the things at the constitutional level that I think has been valuable in Ireland is the fact that to amend the Constitution, which we do quite frequently, you require a full referendum of the people. And there have been 32, I think, successful amendments since the Constitution was initially adopted in 1937. And I think that gives the public sort of an ownership of the Constitution. So when a court is saying the Constitution requires this or doesn't allow that, it's dealing with a text of which the public feels a sense of ownership. And I think that's a valuable counterweight to the idea that these are important decisions being made by some small group of elite people sitting in a Supreme Court somewhere. And therefore, the court did suggest, in reference to the argument that was made that there are countries that many countries, as we've heard earlier, more than 100, that recognize environmental rights in their constitution. The court made the point that in the vast majority of those cases, the rights have been specifically written into the Constitution, and that there were different models of doing so, and that the way in which environmental rights are constitutionally recognized can vary from country to country. So without ruling out the possibility of constitutional rights playing a role in environmental litigation, the court expressed the view that it might be preferable if it was done through a democratic process of the people adopting some formula of environmental rights and expressly including them. And I think that would lead to much greater acceptance of courts' decisions, where the court was simply implementing wording that had been agreed by the people. But as a backstop, the court made it clear that if that didn't happen, it would be prepared to consider in an appropriate case whether there was a constitutional dimension. Finally, I suppose it's always worth reflecting on what happened next. I know a recent conference of this forum specifically addressed a series of cases which had been to the CJEU and asked the national courts to which those judgments went back, well, what good did that do? And that was a very useful exercise. So it's worth perhaps just briefly touching on what happened next. Well, interestingly, between the time of the adoption of the 2015 Act and the judgment of the court in July 2020, there was a change of government. And the Minister for the Environment, by the time the judgment came out, happened to be the leader of the Green Party of Ireland, which had then become a minority party in the government. So perhaps, not uniquely, but unusually, maybe the government for once was reasonably happy to get a judgment which struck down one of its measures, because it transpired that the minister concerned probably rather liked the judgment and gave strength to that minister's argument about requiring better legislation and certainly a much better plan. And since the decision of the Supreme Court in FIE, there has been significant amendments to the legislation, which I think, while they're not universally welcomed, certainly strengthen it to some extent. And there is now a new plan, which is, again, not free from criticism, but which hasn't been the subject of significant legal challenge as yet, and is certainly a lot more detailed than the previous plans, though it is now reaching that critical stage, to return to a point I made a little earlier, where the government is having to be specific about precisely what level of burden each of the major sectors are going to have to take. And that is leading, hardly surprisingly, to significant political debate, because each sector is putting forward its case for doing a bit less so that everyone else has to do a bit more. But I think it would be fair to say that this legislation, in the words of one leading Irish academic commentator on environmental law, Onya Ryle of UCC, gave teeth to the 2015 Act. That act was criticized at the time it was entered into as being perhaps very aspirational because it didn't include specific targets. But I think at least the decision of the court gave some teeth to it and perhaps informed the subsequent legislation and subsequent planning, which reflect the requirement for a much greater level of detail, which the court said needed to be provided. Thanks very much.
Merci, Franck. Et maintenant, on va voir ce qui se passe en France avec deux affaires connues. D'abord, l'affaire du Conseil d'État, commune de Grande-Sainte, et d'autre part, l'affaire du tribunal administratif de Paris, l'affaire du siècle contre la France. Et on est très heureux d'avoir ici parmi nous Fabien Reynaud, le président adjoint, rapporteur général de la section du rapport et des études du Conseil d'État, donc notre hôte pour ces 2 jours de conférence. La parole est à...
Merci beaucoup. Donc, j'ai le privilège de présenter 2 affaires et pas une seule, et chaque affaire ayant été l'occasion de 2 décisions rendues par chaque cour. Donc, je vais essayer quand même de ne pas parler trop longtemps et de ne pas dépasser mon temps de parole. Je crois que ce qui est intéressant aussi dans ces affaires par rapport à celles que l'on vient d'entendre d'Irlande ou tout à l'heure de nos collègues néerlandais et britanniques, c'est ça met aussi en lumière les choix des requérants. C'est-à-dire que non seulement il y a les différents systèmes juridiques, mais il y a aussi les différents champs de bataille choisis par les différents requérants. Donc, nous, dans notre cas, il y a eu donc une première affaire qui a été présentée par la commune de Grande-Sainte et par le maire de cette commune, j'y reviendrai, devant le Conseil d'État, en premier et dernier ressort, contre un refus de prendre des mesures supplémentaires pour lutter contre les émissions de gaz à effet de serre. Ça, c'est la première affaire. Et elle est venue devant le Conseil d'État directement parce que le Conseil d'État français est compétent en premier et dernier ressort pour connaître des actes réglementaires que prend le gouvernement ou du refus de prendre des actes réglementaires. Et là, comme ce qui était attaqué, c'était le refus de prendre toute mesure, ça incluait aussi possiblement des actes réglementaires, enfin le refus de prendre des actes réglementaires. La deuxième affaire, donc, elle a été introduite par une série d'associations qui se sont regroupées sous le vocable l'affaire du siècle, et elle a été introduite devant le tribunal administratif de Paris sur un terrain de responsabilité de l'État. Là, ce qui était en cause, c'était la responsabilité de l'État que recherchaient ces associations dans l'inaction, ou du moins l'action insuffisante que l'État français faisait pour réduire les émissions de gaz à effet de serre, et les dommages qui en résultaient, dont ces associations demandaient la réparation pour le passé et pour l'avenir. Et là, le tribunal administratif de Paris était compétent en premier ressort selon les règles habituelles de compétence au sein de la juridiction administrative. Voilà pour expliquer un peu. Et donc, c'est le choix de ces défenseurs de l'environnement, l'un d'aller devant le Conseil d'État sur un terrain de recours en annulation et l'autre devant le tribunal administratif sur un terrain de responsabilité. Alors, je vais commencer par présenter la décision rendue par le Conseil d'État dans l'affaire commune de Grande-Synthe, en rappelant donc rapidement comment s'est noué le contentieux. Donc, comme je le disais, en 2018, la commune de Grande-Synthe a en fait suscité des décisions en saisissant le gouvernement d'une demande tendant à ce que l'État prenne davantage de mesures pour réduire les émissions de gaz à effet de serre en provenance de la France. Le Premier ministre n'a pas répondu à cette demande et, selon le droit français, une décision négative est née de ce refus et la commune de Grande-Synthe et donc son maire ont attaqué devant le Conseil d'État en 2019 ce refus de prendre ces mesures supplémentaires. Alors, les requérants invoquaient devant nous toute une série d'actes juridiques. Ils invoquaient la Constitution, la Convention européenne des droits de l'homme, en s'inspirant de l'affaire EUFJE. Ils invoquaient également les accords de Paris, la loi française et également le règlement européen qui mettait en œuvre les accords de Paris pour l'Union européenne. Du côté du gouvernement, la ligne principale de défense était l'irrecevabilité du recours, non pas tant en raison de l'acte en cause, parce que ça, notre jurisprudence admet depuis longtemps qu'on puisse attaquer le refus de prendre un acte réglementaire. Alors là, c'était un peu élargi, mais ça rentrait dans le cadre de la jurisprudence, mais en contestant l'intérêt pour agir de la commune de Grande-Synthe dans cette affaire. Alors, la réponse du Conseil d'État a été donnée en deux temps. Donc, il y a eu une première décision, une décision qu'on appelle avant dire droit, donc décision qui fixe le cadre juridique du litige, qui a été rendue le 19 novembre 2020. Et dans cette décision, le Conseil d'État s'est prononcé sur 3 points. Le premier point, c'est d'abord sur la recevabilité de la requête. Donc là, il a donné tort à l'État et il a admis la recevabilité de la requête en tant qu'elle émanait de la commune de Grande-Synthe, en estimant que la commune de Grande-Synthe faisait état d'un certain nombre d'éléments qui lui étaient spécifiques et qui permettaient d'estimer qu'elle était particulièrement concernée par les conséquences du changement climatique. La commune de Grande-Synthe, c'est une cité qui est au bord de la mer du Nord, dont une partie du territoire est inférieure au niveau de la mer et qui est très exposée au risque de submersion marine en cas donc, de changement climatique. Donc, la commune de Grande-Synthe avait caractérisé son cas de manière assez développée et donc le Conseil d'État, en se fondant sur ces différents éléments, a admis l'intérêt pour agir de la commune de Grande-Synthe. Donc, en creux, il considère que d'autres communes n'auraient pas nécessairement eu intérêt pour agir. L'idée, c'est d'en rester à l'approche habituelle du Conseil d'État, qui est aussi une approche assez partagée par les juridictions en Europe, d'avoir un prétoire qui soit suffisamment ouvert pour permettre qu'on puisse accéder au juge, mais d'éviter l'action popularis, d'éviter que le prétoire soit tellement ouvert que tout le monde puisse saisir le juge. Ce qui est évidemment un risque dans ces affaires de changement climatique, parce que, comme on l'a dit à plusieurs reprises ce matin, le changement climatique, ça concerne tout le monde, et non seulement en Europe, mais dans le monde entier. Donc, pour bien souligner cet équilibre, en revanche, le Conseil d'État a estimé que la requête n'était pas recevable en tant qu'elle émanait du maire de la commune qui saisissait en tant que citoyen, mais sans faire valoir le moindre élément particulier attaché à sa personne qui justifierait donc qu'il ait un intérêt spécifique pour agir. Donc ça, c'est le premier point donc, sur l'intérêt pour agir, qui est un élément important pour essayer de trouver un équilibre entre l'action popularis et un prétoire excessivement fermé. Le deuxième point, c'est que le Conseil d'État a admis l'intervention d'un certain nombre d'associations et de collectivités territoriales qui s'étaient joints en intervention au soutien de la commune de Grande-Synthe. Et le dernier point, c'est cette décision a permis au Conseil d'État d'éclairer le cadre juridique du litige. Et là, c'est ce que le Conseil d'État a choisi, a développé comme raisonnement. C'est un raisonnement qui s'est fondé sur la loi française. Comme le disait le collègue irlandais tout à l'heure, le Conseil d'État a relevé que le législateur français était intervenu à la suite des accords de Paris pour préciser quels étaient les objectifs à atteindre en France pour la réduction des émissions de gaz à effet de serre pour 2030. Et le législateur, en se référant expressément aux accords de Paris, a indiqué que l'objectif de réduction des émissions de gaz à effet de serre pour 2030 était de moins 40% par rapport à 1990. Et donc, le Conseil d'État a considéré que, certes, les accords de Paris n'étaient pas d'effet direct. Nous, contrairement à l'Irlande, nous sommes un pays moniste, donc le droit international est invocable directement devant nous, mais à certaines conditions, et notamment à la condition qu'il soit d'effet direct. Donc, les accords de Paris, en application de notre jurisprudence, ne sont pas d'effet direct, puisqu'ils renvoient à des mesures nationales, mais ce que nous avons jugé, c'est que, sans être d'effet direct, ils avaient une valeur interprétative pour interpréter les actes nationaux qui avaient été pris pour mettre en œuvre ces accords. Et donc, nous avons considéré que les moins 40% pour 2030 qui avaient été fixés par le législateur pour mettre en œuvre les accords de Paris n'étaient pas un pur objectif, j'allais dire décoratif, mais était un objectif qui avait une valeur juridique invocable devant le juge. Donc ça, c'était le point essentiel de cette décision qui fixait le cadre juridique du litige. Et nous avons relevé également que le législateur non seulement avait fixé cet objectif, mais avait renvoyé au pouvoir réglementaire le soin de définir des objectifs intermédiaires qui définissaient en réalité une trajectoire pour atteindre l'objectif de 2030. Alors, après avoir pris cette première décision, nous avons laissé quelques mois aux parties pour éclairer sur le cadre juridique sur lequel le Conseil d'État, sur la base duquel le Conseil d'État allait juger, pour que les parties puissent apporter des éléments nouveaux dans le débat afin que nous nous prononcions sur le fond. Et donc, ça a conduit à la deuxième décision, la décision du 1er juillet 2021, par laquelle nous avons jugé deux choses. D'abord, nous avons donné raison à la commune de Grande-Synthe et nous avons estimé que le refus de prendre des mesures supplémentaires que la commune de Grande-Synthe attaquait n'était pas compatible avec le respect de la trajectoire tel qu'il résultait des textes que le gouvernement lui-même avait pris, qui était le décret qu'il avait pris en application de la loi pour définir cette trajectoire. Et ce qui est important, donc, c'est le terme compatible, ce qui veut dire que ce n'est pas une conformité stricte, c'est un contrôle un tout petit peu plus distancié, mais nous avons estimé que, compte tenu du fait que la trajectoire qui avait été définie par le décret avait été dépassée par le passé et que les réductions récentes étaient liées au confinement, il n'était pas possible de dire que des mesures supplémentaires n'étaient pas nécessaires. Et d'ailleurs, le gouvernement lui-même ne contestait pas vraiment ce point, puisqu'il disait « mais nous sommes en train de préparer un projet de loi que nous allons soumettre au gouvernement pour prendre des mesures supplémentaires ». Donc, nous avons estimé que la commune de Grande-Synthe avait raison lorsqu'elle disait que des mesures supplémentaires étaient nécessaires. Et donc, le deuxième point, nous avons donc annulé la décision attaquée et nous avons enjoint au gouvernement de prendre des mesures supplémentaires dans un délai de 9 mois, enfin le 31 mars 2022. Alors, ce que je voudrais souligner sur ce point, c'est que nous avons laissé un délai qui était relativement bref, mais nous n'avons rien dit sur ce que ces mesures devaient être. Car là encore, il faut faire l'équilibre entre ce que le juge peut faire et ce qu'il ne peut pas faire. Et nous avons estimé que ce n'était pas à nous de dire quelles mesures précises devaient être prises. C'était du ressort des autorités démocratiquement élues, le gouvernement, voire le Parlement, s'il était nécessaire de modifier la loi. Donc, nous sommes maintenant dans une situation dans laquelle la question qui se pose maintenant, c'est de savoir si la décision du 1er juillet 2021 est exécutée. Alors, là, j'allais dire, cette question va être encore plus difficile que les précédentes, parce que dans les précédentes, et notamment dans la décision du 1er juillet 2021, il était assez clair que des mesures supplémentaires étaient nécessaires, et comme je l'ai dit, l'État ne le contestait pas vraiment. Il était en train de dire « on en prépare ». Bon. Là, on va être devant une situation plus délicate parce que l'État met en avant toutes les mesures qui ont été prises dans le cadre de la loi climat et résilience qu'il a fait entre-temps adopter par le Parlement et les décrets, les actes réglementaires qui ont été édictés par le gouvernement depuis lors et qui sont assez substantiels. Mais en même temps, les associations, en se fondant sur un certain nombre d'éléments objectifs, notamment les avis qui ont pu être rendus par le Haut Conseil sur le climat, considèrent que ces mesures, pour réelles qu'elles soient et pour importantes qu'elles soient, demeurent insuffisantes pour être compatibles avec la trajectoire qui fixe moins 40% en 2030, et ce d'autant plus que l'objectif de moins 40% est en train d'être révisé et va être durci. Donc là, il y aura donc une troisième décision du Conseil d'État qui va être techniquement compliquée à rendre, mais que le juge est bien obligé de rendre, qui va être d'apprécier si les mesures prises par le gouvernement depuis la décision du 1er juillet 2021 sont suffisantes pour qu'on puisse regarder comme exécuter la décision que nous avons rendue. Je crois. Il me semble qu'un élément qui va être essentiel dans ce débat, mais là je m'avance puisque c'est encore un point qui est en débat, c'est la capacité du gouvernement à établir que lorsqu'il a pris ces mesures, les mesures qu'il invoque devant le juge, il avait fait un effort pour mesurer les effets qu'il espère de ces mesures sur les émissions de gaz à effet de serre. Évidemment, c'est une appréciation qui est très difficile parce que les émissions de gaz à effet de serre, elles sont émises par tout le monde, par toute l'activité économique, dans sa diversité. Mais il me semble qu'on est en droit d'attendre du gouvernement, compte tenu de ce que c'est lui, enfin c'est le Parlement qui a fixé l'objectif et c'est lui qui a pris les décrets, qu'il soit capable d'expliquer de manière un minimum démontrable quel effet concret il attend sur les émissions de gaz à effet de serre des mesures qu'il a prises. Donc, nous verrons ce que le Conseil d'État jugera. S'il estime que les mesures sont insuffisantes et que sa décision n'a pas été pleinement exécutée, il sera en mesure de mobiliser les compétences qu'il a à sa disposition, notamment il pourra infliger une astreinte financière, comme il l'a fait dans d'autres affaires, notamment sur la qualité de l'air, une astreinte financière à l'État. Alors, j'irai plus rapidement pour présenter la deuxième affaire, celle du tribunal administratif de Paris, pour la bonne raison que ces décisions ont été rendues un peu après celles du Conseil d'État à chaque fois et qu'elles sont, c'est heureux, cohérentes avec celles que le Conseil d'État a rendues. Et donc, le tribunal administratif de Paris s'est prononcé sur un terrain différent, puisque c'est, comme je le disais, un terrain de responsabilité, mais avec le même raisonnement juridique que celui que nous avions suivi. Alors, il s'est prononcé lui aussi en deux temps. Le premier temps, c'est un premier jugement du 3 février 2021 qui, là encore, a fixé le cadre général du litige. Alors, dans ce jugement du 3 février 2021, le tribunal administratif a jugé 4 points importants. D'abord, il a estimé que le préjudice écologique invoqué par les requérants devait être regardé comme établi. Ça, c'était la partie, j'allais dire, la plus facile. C'était la partie consistant à dire les émissions de gaz à effet de serre ont un effet sur le réchauffement climatique et donc il y a un préjudice écologique dans les émissions de gaz à effet de serre. Le deuxième point, c'était moins évident, c'était celui d'établir un lien de causalité entre l'action de l'État et ce préjudice. Alors là-dessus, le tribunal administratif s'est fondé sur la logique des accords de Paris, qui ont été rappelés et qui considèrent, le collègue néerlandais l'a rappelé, donc je pourrais aller rapidement, qu'il ne faut pas prendre une action isolée d'un État, mais considérer qu'il y a une globalité dans l'action des différents États et que donc le fait que l'un ne remplisse pas ses objectifs a des conséquences générales. Donc, le deuxième point, le tribunal administratif a estimé que le lien de causalité était bien réel entre le préjudice qu'il relevait et l'action de l'État qui était contestée devant lui. Et troisième point, il a estimé que pour les années 2015-2020, donc les années passées par rapport à son jugement, il y avait bien eu une faute de l'État qui n'avait pas respecté la trajectoire qu'il s'était lui-même fixé, comme je le disais, par les décrets qu'il avait pris, et qu'il y avait donc un surplus d'émissions de gaz à effet de serre qui avait été envoyé dans l'atmosphère. Et en conséquence, il a, pour le préjudice passé, il a condamné l'État à 1 euro de dommages et intérêts, qui était ce que lui demandaient les associations. Les associations, pour le passé, demandaient 1 euro de dommages et intérêts, mais ce n'était pas ça l'important pour elles, c'était symbolique, mais c'était surtout pour l'avenir. Les associations ont demandé que pour l'avenir, l'État fasse cesser ce dommage, et pour répondre à cette deuxième demande, le tribunal administratif, comme le Conseil d'État avait fait, a demandé un supplément d'instruction pour permettre aux parties donc, de lui apporter des précisions sur le point de savoir si ce préjudice perdurait, et si ce préjudice perdurait, comment y mettre fin. Alors, dans son second jugement du 24 octobre 2021, le tribunal administratif a relevé que le préjudice perdurait, en se fondant sur le fait que même si les émissions avaient baissé à cause du confinement, on ne pouvait pas relever de tendance générale à la baisse de ces émissions. Et par ailleurs, il a estimé que si on regardait les émissions de gaz à effet de serre, le trop-plein d'émissions de gaz à effet de serre qui avait été envoyé dans l'atmosphère entre 2015 et 2020, une partie de ce trop-plein avait été, j'allais dire, absorbée par le fait que pendant le confinement, on avait émis beaucoup moins d'émissions de gaz à effet de serre que ce qui avait été prévu par la trajectoire. Mais il a estimé que si on faisait ce surplus moins l'effet bénéfique du confinement, il restait quand même un solde négatif de 15 millions de tonnes équivalent CO2, et que ce 15 millions de tonnes équivalent CO2 avait été envoyé dans l'atmosphère, avait eu un effet dommageable, et que ce que le gouvernement devait faire pour réparer ce préjudice, c'était s'assurer que dans la période à venir, il y aurait 15 millions de tonnes en moins qui seraient émis par rapport aux objectifs fixés par la trajectoire. Donc, un positionnement très ambitieux. Voilà pour la présentation de ces deux affaires. Pour conclure, ce que je voudrais dire très rapidement, c'est que je crois que ce qui est intéressant dans ces affaires, c'est le fait que le juge administratif français, il s'est fondé sur le droit national qui avait été mis en œuvre pour la mise en œuvre des accords de Paris. Et je crois qu'il a essayé de cette manière de donner aux accords de Paris le plein effet juridique possible, au-delà du fait qu'ils n'étaient pas invocables, même dans un pays moniste comme la France. Et donc, l'idée, c'est de faire en sorte que cet instrument, qui est finalement le seul instrument global dont nous disposions, ait le plein effet juridique possible, puisque nous le savons tous, la lutte contre le changement climatique ne peut avoir une chance de succès que si elle est menée globalement. Donc, puisque tout dépend de l'action globale, autant donner le maximum d'effets possibles, et notamment la plus grande portée juridique possible au seul instrument global dont nous disposons, à savoir l'accord de Paris. Je vous remercie de votre attention.
Maintenant, on va se déplacer un peu vers le nord, le Norvège. Je suis très heureux d'avoir Ragnhild Noor ici, juge à la Cour suprême de Norvège et impliqué déjà pendant beaucoup d'années aux instituts global judiciaires de l'environnement. Et elle va nous parler de Nature and Youth and Greenpeace Nordic versus the government of Norway. Please.
Is this functioning? Yes. So it's up to me at the end of the day to talk about the case where the environmental groups did not win the case. I will try. Do you have the PowerPoint? Yeah, because the subject matter of the case was a decision to award 10 petroleum production licenses in the sea north of Norway. And you know, in this area, the nature is vulnerable, and oil and gas gives rise to CO2 emissions. So that was the reason why these nature organizations filed the case. Next. Yeah, you see the map there where these licenses were given to explore, to look for oil. And the key question was whether this decision was in breach of the Norwegian Constitution's Article 112, which gives people the right to a healthy environment. And it was also discussed, which I will come back to, whether the decision was in breach of the right to life and the right to private and family life. And there was also, lastly, a question of environmental impact assessment. The parties of the case, the appellants, were the Nature and Youth Norway and Greenpeace Nordic, the two environmental groups, and the respondent was the state of Norway, represented by the Ministry of Petroleum and Energy. And the environmental groups had lost the case in the district court and in the High Court, and the case was dealt with by the Supreme Court of Norway, sitting in plenary with 15 of its 20 judges. I did not participate, so I cannot be blamed for this. Farah? Yeah. So here you see the companies, they were, okay, can you go back to the picture? The companies, they were given the license to explore, to try to find out whether there was oil and gas under the sea bed. And as you know, Norway is an oil and gas producer. We are producing 3% of global demand for crude oil and 2% of global demand for natural gas. At the same time, Norway is part of the EU emission trading system. And so we are part of the EU climate politics. Next. The justice who wrote the decision, he started the opinion with stating that there is no doubt that climate is changing due to greenhouse gas emissions, and that these changes may have serious consequences for life on Earth. And this is a long judgment, and he writes quite a lot about climate change and which impacts it will have. But I can, of course, not go into detail in that, but there was clearly stated in the judgment that climate change is a serious risk to life on Earth. So we can go on to the next. And this is how petroleum activities are regulated in Norway. First, there is an opening of a field, which had already happened here. And then there is an exploration phase where the companies are given license to search for oil and gas. And that is where we are. In this case, these companies had got the license to investigate and to make exploration drillings. And then if the companies find oil or gas, they need a new license to start production. And that is something which the court puts emphasis on in its later ruling. But it should be said that up till now, it has a company who has found oil and gas has always got a production license if they have found oil and gas. But still, they need such a license. At the time of the case, when the case was handled in the Supreme Court, 3 of the 10 licenses had been relinquished, which means that the companies, they hadn't found oil and gas in these areas. And as by today, all the licenses have been given back to the authorities because no profitable discoveries have been done. So we know the result now. There will be no emissions from these licenses, but that, of course, you couldn't know at the time when the decision was reached. Article 112 of the Norwegian Constitution says that every person has the right to an environment that is conducive to health and to a natural environment whose productivity and diversity are maintained. And in the last part, it says that the authorities of the state shall take measures for the implementation of these principles. And the question for the court was whether the decision was in accordance with this, and also, next slide, whether there was this statute gave a legal basis for an invalidity claim. And the court went very deep into the preparatory work of this statute and found there that it was said that this statute in the Constitution was not meant to give powers to the courts, or not too much power to the courts, but I will come back to that. Next slide. This is this case. It was went on during the Corona times. So you see to the left a picture of the Supreme Court and a melting globe before it, and then you see the pictures of the lawyers, and they were in separate chambers, as it was during Corona times. Yes. So I will go quite kind of quickly to what was the ruling of the court, and the court was unanimous on this. And as I said, they went into the background and the preparatory works of the constitutional provision and said that the clear starting point is that it is for the authorities to decide which measures to be implemented. And then they said what is stated on the PowerPoint. On the one hand, obvious rule of law considerations suggest that the courts must be able to set limits on the political majority when it comes to protecting constitutional values. On the other hand, decisions involving fundamental environmental issues often involve political balancing of interests and broader priorities. Democracy considerations therefore suggest that such decisions should be made by popularly elected bodies and not by the courts. Do you agree? Well, that was at least the view of the court, that this was more politics than it was law. And I think part of the, and they also said that against this background, the Article 112 of the Constitution must, when the Storting, that is the Parliament, has considered a case, be interpreted as a safety valve. In order for the courts to set aside a legislative act of the Storting must have grossly neglected its duties under Article 112. The same must apply for other parliamentary decisions and decisions to which the Storting has consented. Consequently, the threshold is very high, and the court concluded that this threshold was not breached. I think it should be said that this question of whether to open the Barents Sea for oil exploration had been discussed thoroughly in the parliament and many times, and there had been several bills to stop this licensing round, but all these bills were rejected by the parliament with a broad political majority. So there was kind of no doubt about what the parliament meant about this thing. And then I think it's also one other aspect, and that is that I think the court felt that if they gave the environmental groups, if they won the case, that would have big consequences for the Norwegian oil and gas politics in general. They said that the arguments of the environmental groups imply that crucial parts of the Norwegian petroleum policy with production and export are put to the test. These views will also affect subsequent licensing rounds and largely involve a controlled phase out of Norwegian petroleum activity. This is not a subject matter in this case, or I think one can say that the court felt that that was too big a task for it to go into. And here you see how the court looked like when the judgments was read out loud, and the justice who wrote the decision, you can see him on the top. The court also discussed whether this decision to give licenses to look for oil in the Barents Sea was contrary to other human rights, but concluded that it was not. And as I mentioned, this part of the judgment was unanimous. But then the court went on to discuss whether there was wrongdoings in the way the parliament had assessed the consequences of their decision before it was reached. And they said the issue is whether an impact assessment should have been made on possible combustion emissions that would occur in the event that, after the opening, production licenses were awarded and subsequently a PDO, a license, was approved. And in that case, whether that constitutes an error that invalidates the later decision on production licenses. So the thing is that there was made impact assessments before the licenses were given, but these impact assessments did not include an assessment of what would be the consequences if one found oil and gas, and this oil and gas was exported, and which emissions the combustion of this oil and gas then would lead to. Eleven justices said that this was no significant procedural error. And they emphasized that a production license, which means in fact a license to search for oil and gas, is not an unconditional right to extradition, even if profitable discoveries should be made. And they say that if oil and gas was found, then there would be, then the government would have to make this assessment. And they said, okay, this is good enough. And they also said that because these decisions had been discussed, as I said, very many times in the parliament, and they knew what they did. But 4 justices saw it in another way, and they found that the decision to give licenses therefore was invalid. And they say they used the SAR directive, Strategic Environmental Impact Assessment Directive, and said that you can't postpone the consideration of important aspects of the environmental effects as the estimates become more certain and detailed at a later stage, when you know whether there are oil and gas there or not. They said that these assessments must be done in an early stage when the strategic choices are made. So a small victory for the environmental groups with what these 4 judges said. And then the judgment, you can, the result is here. The judgment is available in English and available online. What has happened after the judgment is that it has been appealed. The judgment has been appealed to the European Court of Human Rights. And in December 2021, the Court of Human Rights characterized the case as a potential impact case and communicated it to the Norwegian state. But then the court now has decided to postpone the proceedings in this case, pending the outcome of the 3 other climate cases, which are now being handled from Portugal, Switzerland, and France. And so what will be the result in the end? We still don't know. Thank you.
Donc peut-être ajouter que l'affaire de la France devant la Cour européenne des droits de l'homme, c'est le maire de Grande-Synthe dont l'intérêt n'était pas accepté par le Conseil d'État. So, je pense qu'il faut maintenant se tourner vers le Luxembourg et on va écouter notre ami de longue date, membre de longue date, le juge Jan Passer, pour nous donner un panorama de la jurisprudence de la Cour de justice de l'Union européenne et j'espère que la santé est revenue entre temps. So, Jan, you have the floor.
Merci beaucoup, Luc. Tout d'abord, je voudrais remercier les organisateurs de la conférence pour avoir pris soin de cet événement et je voudrais les honorer en utilisant la langue de Molière dans mon allocution, ce qui est notamment pertinent au Palais Royal, bien évidemment. Je voudrais aussi saluer les collègues du forum après très longtemps, même si je suis désolé de ne pas pouvoir être avec vous physiquement à Paris. Je suis heureux de pouvoir vous rejoindre au moins par la vidéo. De nombreux procès relatifs à l'environnement et notamment au changement climatique ont émergé dans le monde depuis les années 2000 et se sont multipliés depuis 2015. La Cour de justice a également été saisie de la question climatique au travers de différentes procédures, notamment par des recours en annulation directement introduits par des particuliers ou des associations. Cependant, les autres types de procédures sont également importants, même si nous n'avons pas encore vu nécessairement les aspects du litige sur le changement climatique. Toutefois, ils nous montrent les tendances et aussi les obstacles auxquels les litiges en matière de changement climatique seront confrontés. Je vais commencer ma présentation en évoquant les recours en annulation. Selon le traité sur le fonctionnement de l'Union, une personne physique peut introduire un recours en annulation devant la Cour de justice dans un des 3 cas suivants. Si elle est la destinataire de l'acte, si elle est directement et individuellement concernée par l'acte, ou si l'acte attaqué est un acte réglementaire qui la concerne directement et qui ne comporte pas de mesures d'exécution. Le critère pour démontrer l'existence d'une affectation individuelle a été établi déjà dans l'arrêt Plauman, selon lequel l'acte en cause doit atteindre le particulier en raison de certaines qualités qui lui sont particulières ou d'une situation de fait qui le caractérise par rapport à toute autre personne et de ce fait l'individualise d'une manière analogue à celle du destinataire. Ces conditions sont exigeantes et, par conséquent, la porte d'entrée de la Cour reste difficilement accessible pour les personnes physiques et morales. Dans les affaires relatives au climat, la question du locus standi des particuliers est encore plus délicate. Peut-on conclure que les personnes physiques et morales qui entendent un recours devant la Cour de justice sont individuellement affectées par des actes ayant un impact au niveau du changement climatique? Cette question a été posée dans l'affaire connue sous le nom People's Climate Case. Les requérants sont des familles originaires de divers États membres de l'Union, du Kenya, des îles Fidji, ainsi qu'une association suédoise représentant les Samis. Ces requérantes ont introduit en 2018 un recours devant le tribunal de l'Union européenne visant à ce que l'Union adopte des mesures plus sévères que celles prévues par un paquet législatif de 2018 en termes de réduction des émissions de gaz à effet de serre. Elle demandait en particulier l'annulation de ce paquet législatif en ce qu'il fixe un objectif de 40% de réduction des émissions de gaz à effet de serre à l'horizon 2030 par rapport au niveau de l'année 1990 et, au lieu d'une indemnité pécuniaire pour leurs prétendues pertes individuelles, d'ordonner au Conseil de l'Union européenne et au Parlement d'adopter des mesures imposant une réduction comprise à tout le moins entre 50 et 60%. Le tribunal a jugé ce recours irrecevable. Les auteurs du recours ne satisfaisant à aucun des critères relevant de la qualité pour agir. Il a estimé en particulier que les requérants n'étaient pas individuellement affectés par le paquet législatif. La Cour de justice a confirmé l'ordonnance du tribunal. Ce faisant, la Cour confirme que les conditions prévues au traité et le critère établi dans l'arrêt Plauman ne peuvent être assouplis en l'espèce. La Cour souligne notamment que l'allégation selon laquelle un acte de l'Union viole les droits fondamentaux ne suffit pas à elle seule à rendre recevable le recours d'un particulier sous peine de vider les conditions de recevabilité posées par le traité de leur substance. Elle rappelle, par ailleurs, que le juge de l'Union ne peut pas, sans excéder ses compétences, interpréter ces conditions d'une manière aboutissant à s'écarter de ce qui est expressément prévu par le traité, et ce même à la lumière du droit fondamental à une protection juridictionnelle effective consacrée par la Charte des droits fondamentaux de l'Union. Dans l'autre affaire, Peter Sabo et autres contre Parlement et Conseil, la demande portait sur l'annulation des dispositions de la directive 2018/2001 qui permettent de compatibiliser l'énergie issue de la biomasse forestière comme une source d'énergie renouvelable. Dans cette affaire, la question de l'atteinte à la vie privée et familiale avait été soulevée par un citoyen américain confronté à la baisse du nombre d'animaux qu'il chasse habituellement dans son bois en raison de la réduction de leur habitat due aux coupes de forêts voisines. La directive européenne contestait, en incluant la biomasse forestière comme une source d'énergie renouvelable participerait donc à l'atteinte à son droit subjectif et constituerait une politique néfaste pour le climat à court terme. Aussi dans cette affaire, la Cour a répété que l'atteinte alléguée au respect des droits fondamentaux des requérants ne saurait permettre, en tout état de cause, d'écarter l'application des critères de recevabilité fixés expressément par le traité. Par ces deux arrêts, la Cour confirme donc qu'il n'y a pas lieu d'assouplir les critères établis dans l'arrêt Plaumann. Il n'y a donc pas de règles spécifiques de locus standi pour les affaires relatives au changement climatique. Néanmoins, je tiens à signaler qu'une révision du règlement 1367 de 2006 concernant l'application aux institutions et organes de la Communauté européenne de disposition de la Convention d'Aarhus vient d'être actée, révision qui a vocation à ouvrir plus largement le champ d'application d'une procédure qui permet à toute ONG de demander à l'auteur d'un acte pris dans le domaine de l'environnement son réexamen interne. Parce que cette procédure administrative peut, en cas de réponse négative, déboucher sur un recours devant le juge de l'Union. Une telle révision pourrait donc produire des effets. Ensuite, quelle est la situation avec les recours en manquement? De nombreuses procédures en manquement ont été introduites par la Commission à l'égard des États membres dans le domaine de l'environnement, même si pas nécessairement dans le domaine du changement climatique. Mais il y a un lien clair avec le domaine qui était mentionné par mon prédécesseur dans l'allocution, Fabien Renaud. Et je veux l'adresser notamment dans la partie suivante de mon allocution qui touche la question préjudicielle. Pour les procédures de manquement, on peut notamment citer le recours en manquement concernant la directive sur la qualité de l'air. Elle prévoit une obligation de ne pas dépasser certaines valeurs limites de concentration dans l'air de 13 polluants atmosphériques et lorsque le dépassement des valeurs limites a lieu après le délai prévu, l'État membre a l'obligation d'établir un plan relatif à la qualité de l'air afin d'atteindre les valeurs limites. Ainsi, des condamnations en manquement par la Cour de justice sont déjà intervenues à l'encontre de plusieurs pays membres. Mais à part ça, il y a encore un chemin à la Cour de justice via une juridiction nationale et une question préjudicielle. Je vais parler notamment d'une affaire. La directive relative à la qualité de l'air, ainsi que la jurisprudence dont je viens de parler, a donné lieu à une jurisprudence fournie en matière préjudicielle de la part de la Cour de justice. En effet, les personnes physiques ou morales directement concernées par le dépassement des valeurs limites ont invoqué la directive en vue d'obtenir des autorités nationales, le cas échéant en saisissant les juridictions compétentes, l'établissement d'un plan relatif à la qualité de l'air. En outre, cette jurisprudence a précisé les obligations du juge national en ce cas. Ce dernier a en effet, au titre du droit de l'Union, l'obligation de prendre toutes mesures nécessaires, telle une injonction, si elle est prévue par le droit national, afin que l'autorité compétente établisse ce plan dans les conditions prévues par la directive. Les arrêts Janecek, Client Air et Kreinest. Mais je voudrais terminer par une affaire récente qui est extrêmement intéressante et qui est encore pendante devant la Cour. En fait, la Cour administrative d'appel de Versailles a posé une question concernant la responsabilité de la France pour le dépassement des valeurs limites de la qualité de l'air ambiant. C'est l'affaire C-61 de 2021. IEP contre ministre de la Transition écologique, Premier ministre. Dans l'affaire au principal, un habitant de l'agglomération de Paris réclame à l'État une indemnisation d'un montant total de 21 millions d'euros, car l'augmentation de la pollution dans cette agglomération a porté atteinte à sa santé. Il estime que cet État membre doit répondre de ses préjudices, car il n'a pas veillé à ce que les valeurs limites uniformément applicables dans l'ensemble de l'Union européenne soient respectées. Cette procédure porte en substance sur les conditions de la responsabilité extracontractuelle des États membres pour violation du droit de l'Union. La première condition concerne le point de savoir si la disposition de la directive ouvre des droits aux particuliers. Il convient en outre d'examiner à quelles conditions une éventuelle violation de la directive est suffisamment caractérisée et comment doit être établie la preuve d'un lien de causalité directe entre la violation et un préjudice. Des conclusions ont été déposées par Madame l'avocate générale Cocotte le 5 mai de cette année et l'affaire est actuellement en délibéré. Dans ses conclusions, l'avocat général estime qu'une violation des valeurs limites prévues par le droit de l'Union aux fins de la protection de la qualité de l'air peuvent ouvrir des droits à indemnisation à l'encontre de l'État. Selon elle, les trois conditions classiques pour l'engagement de la responsabilité de l'État sont applicables également en l'espèce pour le préjudice subi par un particulier en raison de violation du droit de l'Union imputable à l'État. Elle estime, et ça peut être révolutionnaire, que la première condition est remplie car les valeurs limites instaurées par les directives de l'Union pour les polluants dans l'air ambiant et les obligations aux fins de l'amélioration de la qualité de l'air avaient pour objet de conférer des droits aux particuliers. L'objectif principal de ces dispositions suffisamment claires consiste en effet, selon elle, à protéger la santé humaine. Le cercle des personnes dont la demande d'indemnisation est éventuellement susceptible d'être accueillie n'est pas non plus, selon l'avocat général, si étendu qu'il pourrait couvrir presque tout un chacun et que l'on serait, en quelque sorte, tenu de s'indemniser mutuellement par l'intermédiaire des impôts. Elle indique que le dépassement des valeurs limites pèse en fait avant tout sur certaines catégories qui vivent ou travaillent dans des secteurs particulièrement affectés. Ce sont souvent, selon elle, des personnes à faible statut socio-économique qui ont particulièrement besoin d'une protection juridictionnelle. En ce qui concerne, deuxièmement, l'existence d'une violation caractérisée des règles relatives à la protection de la qualité de l'air, cette violation concerne toutes les périodes au cours desquelles les valeurs limites respectivement en vigueur ont été dépassées en l'absence de tout plan d'amélioration de la qualité de l'air, ne présentant aucune lacune manifeste. L'avocat général rappelle que c'est aux juridictions nationales qu'il appartient de procéder à cet examen. Selon l'avocat général, la véritable difficulté pour faire valoir des droits à indemnisation réside dans la troisième condition, à savoir dans l'établissement de la preuve d'un lien de causalité directe entre la violation caractérisée des règles relatives à la protection de la qualité de l'air et le préjudice concret de santé. En conclusion, l'avocat général indique que si la preuve d'un lien direct entre une violation caractérisée des valeurs limites et un préjudice de santé est établie, le dernier mot n'est pas encore dit et c'est pour l'État membre s'exonérer de la responsabilité en démontrant que ce dépassement aurait également eu lieu s'il avait adopté en temps utile de plans relatifs à la qualité de l'air conformes aux exigences prévues par la directive. Comme j'ai déjà signalé, à présent, l'affaire est en délibéré devant la grande chambre de la Cour. Je ne peux donc me prononcer sur l'issue de cette affaire à ce stade. Cependant, ce qui me semble clair, c'est que le futur arrêt de la Cour et la définition des droits individuels dans ce domaine peuvent avoir des conséquences pour les autres domaines du droit de l'environnement et, surtout, pour les éventuelles plaintes et requêtes dans le domaine du changement climatique. En conclusion, cette brève présentation aura montré, j'espère, qu'il existe plusieurs voies pour saisir la Cour de questions relatives au changement climatique. Ceux qui sont ouverts aux individus sont confrontés à une approche stricte de la Cour en ce qui concerne l'intérêt pour agir. Mais, comme vous avez pu le voir dans la dernière affaire que j'ai mentionnée, il y a une pression permanente sur la définition des droits individuels dans le domaine du droit de l'environnement. En ce moment, je ne peux rien dire de plus que je suis moi-même très curieux de savoir quelle sera la réponse de la Cour. Mesdames et Messieurs, merci pour votre attention. Si je peux, Luc, déjà lancer le débat qui va suivre cette partie du forum. J'aurais moi-même peut-être une question pour Fabien Renaud.
Donc, je propose que le juge ayant pas se pose directement cette question.
Merci beaucoup, merci Luc. Alors, j'avoue qu'on est bien au courant à la Cour de justice de cette jurisprudence